I think we find ourselves at a crossroads now.
No, but you're very
I'll
right
tell
Yeah,
because
I'll tell you
health is
why.
such a large part. Yes,
Yeah,
yes.
I'll tell you why very quickly, and maybe Zainab will want to argue it further. That's okay. We got freedom in 2018 September. You know, when Section 377 was read down, we became equal citizens of this country. But it
Hmm.
was like a shell company be given to us. Nothing was within it. So many roles, responsibilities, rights were not given to the transgender. Of course, a farcical transgender bill was handed down. To us, Section 377 was removed, and despite the fact that not removed, read down, but
Yes.
the bench clearly had told the government that it needs to advise and educate every sector of society on LGBT
Yes.
issues.
Which
That
was
has
not happening.
not happened. Very simple things like even till today.
I seem to have lost the audio.
Ashok, we've lost your audio.
Okay, we come back to Ashok Rao Kavi and Zainab Patel. Just taking our audience, just welcoming our audience into this conversation. Those who are joining us right now, 10:30. We're assembling. We're waiting for the bench to assemble. Uh, excuse me.
That's heralding good news.
We're waiting for the bench to assemble of Supreme Court right now. I'm watching it. As soon as the bench assembles, the first matter of business that the court will take up will be the judgment to the marriage equality case, and we're all waiting for that judgment. I welcome our audience who are coming in right now. We're starting now. So just to explain to our audience why we're calling it marriage equality and not same-sex marriage, as it's being popularly called in, in the rest of the media, same-sex marriage would suggest only marriage between two men or two women who are of the same gender. But here, what is being placed before the court is the ability of people of various genders, people who are non-binary, people who are trans, to be able to get married. So what they're asking is that do not limit marriage anymore only to a man and a woman, open it to other genders as well. So it is equality in marriage across all genders, which is why it's being called marriage equality and not same-sex marriage. A lot of people are calling it same-sex marriage. We have our audience coming in. I'm going to keep an eye on the court. We're waiting for the court, the judges to assemble. Joining us today to have this conversation, we have some really fascinating and interesting guests. We have Ashok Rao Kavi, who was with us. We lost his audio. We're trying to bring him back. He has been an LGBTQI activist since the 80s, and part of the sort of initial fight, to legalize just love in this country. We also have, and with us right now, Zainab Patel. She's one of the petitioners of this very, very important case. She is the head of the inclusion department at Pernod Ricard. Thank you so much, Zainab, for talking to us. So we're waiting for the bench to assemble. And in the meantime, Zainab, I want to understand from you, when you took this petition to Supreme Court, what is it truly that you want out of the court? Because there's a range of things available before the court right now. It seems unlikely at this point the court will say, boom, boom, now you can get married, because it's very complex. What do you hope for from this?
I think Faye, as a petitioner, also in the earlier NALSA case, so I was instrumental in getting NALSA to file the petition against the Union of India and also pleaded in the case. For me, when opportunity provided itself in 2019 to actually file the case in Delhi High Court on marriage equality, for me it was a mixture of both the right to marry as well as the rights of marriage, because there is a lot of time when LGBTIQ couples have been asking, what happens when my partner is grievously ill, when someone is battling a critical situation at home, insurance, pension, inheritance, joint opening of bank accounts, and many other things. I think when we looked at all of that, I think it was incumbent on some of us who both had the privilege as well as the access to the legal corridors to be able to come out in the open and fight this much needed race towards marriage equality. And thank you for correcting and reminding us that this is not only a case limited to same sex marriage, which then would ignore every other non binary trans identity, but it's on marriage equality irrespective of your gender identity or expression.
Yeah.
It's a fight to marriage, so that's what we are actually looking for.
And just to break this down to our audience, and I find this such a powerful idea, right? Heterosexual couples or het cisgender couples take a lot of things for granted. We can, for example, buy insurance and make our spouse the nominee. So if something happens to me, my husband will automatically A, B, inherit everything unless I specify otherwise. So it makes it much easier for the surviving partner at that point to manage bank accounts and to manage, structures. We're allowed to have children. We're allowed to adopt children together. We're allowed to buy houses and buy property together. We're allowed to have joint bank accounts. Um, Simple stuff. When one of us is in the hospital, the other one has the ability to make important decisions towards the care of the injured or the hospitalized spouse or the partner. Same sex, trans couples, non binary couples who are non het, non cis do not have any of these things. So some of them have been together for decades, but they don't have these simple rights. And a lot of them also, which is really important, are estranged from their families who sort of literally throw them out when they discover their identities. And so when one partner then, say, passes away, everything goes back to that original family that rejected this person to begin with, right? And so it's really an unfair sort of way to live where you cannot plan for basic things. So let's imagine two people are in love and live together for 40 years. One person gets sick. That person's partner who's loved and cared for this person for 40 years doesn't have the ability to make a single decision from the point of view of medicals. They have to call the family that rejected this individual 40 years ago. And that is really a sort of terrible denial of rights. And other small things, like PTA meetings, of the ability to have and raise children, the ability to own a house together. These are the things that marriage gives het cis couples, and everybody who doesn't fall into that category is not allowed these basic human rights that we otherwise take for granted. So that is really what this is about: the denial of dignity. And if, as per the Constitution of India, we are truly equal, then this should also be equal. This should not see the Constitution says that we're all equal. B, now the court has said in 2018, like Ashok Kabi was pointing out, that a non-heterosexual relationship is not illegal in India. So then why can't they also have all of the legal rights that come with marriage? That is the fundamental argument that was made. Also, during the arguments that were placed before the Supreme Court, there are, as you know, in India, different personal laws. There's a Muslim Marriage Act, there is a special Hindu Marriage Act, there is a Christian Marriage Act, because each of these traditions are different. Like, for example, under the Muslim Marriage Act, marriage is a contract. That's not the case under the Hindu Marriage Act. Now, the Supreme Court said this is too complicated. We're only going to focus on the Special Marriage Act, which allows people from two different religions to get married. And that is a purely, I know because I've had one of those registered weddings under the Special Marriage Act. It's a very clerical, very legal, there's no tradition involved in it. So that is under the Special Marriage Act. Right now the Special Marriage Act says between a man and a woman, can that bit be changed to include everyone? That is what the court is examining. Ashok Kavi wants to say something. Also, we are fairly close to the court bench being assembled, so you'll have to be a little quick,
Yeah,
Mr. Ravi. Go ahead.
I just think that even if the Special Marriages Act is tweaked, the whole thing is going to come and crash on the personal laws of each religion.
Yes.
For example, a Hindu and a Muslim do get married, but they can't adopt because the Muslim personal law does not allow adoption. You know, so you're already stuck. You can't even give. Suppose one person dies, the brother of the Muslim man can take over the property. that happened in Kerala. So the personal law, this codes of each community, and there are so many, are also a problem. They stand as an obstruction. So you'll have to have a complete architecture where our rights are protected. And I do think that we may have to tweak the Special Marriages Act, and at the same time set up what is called civil partnerships through, but that
Yes.
can only happen through parliament. Zainab, am I right?
See, Ashok, there is a whole lot of different things. Just before the judges come in, I must say that even while India was battling criminalization, I and my partner from Mumbai went to South Africa and got our marriage registered. I also went through a legal a gender affirming process. I got my name. Like you, I am a Mangalorean. I come from the Christian community, but I took on my partner's name and I took on a Muslim sounding name to be able to pass on all benefits. So I am one of those very lucky, privileged few where my partner is recognized in my insurance. His parents are covered under my insurance. He is named in as a nominee, etc. So, of course, we separated just before the hearing started, but we used with mutual consent all of our documents, including our insurance coverage, to make a point for people that as a trans woman, when the court has recognized my gender identity for what I recognize myself and see myself, it should be applicable for all. But as Ashok said, it means different things for different people. We have about 21 petitions with 50 odd people, each looking at it from a different perspective, but largely under the Special Marriage Act and some under the Foreign Marriages Act also. So I guess there is this huge thing to kind of not steer into personal laws at this point of time so as to not ruffle any feathers around religion, etc. But at the same time, recognizing that while a specific reading into the Special Marriage Act, which kind of tweaks the provision, one may need to look at the 150 other provisions in existing laws to kind of look and change them in the near future to be accommodative of marriage equality for all. I'm going to say that and just and pause for the moment.
Yeah, yeah. So, just for our audience who's already joined in, what you can see on your screen is the frame coming in from Supreme Court, 5 judges, including that tallest chair, which will be occupied by the Chief Justice of India, D.Y. Chandrachud. We're waiting for the judges to assemble. Now, this matter was slotted for 10:30 a.m. It's about 15 minutes late. The judges are not seated yet, but it'll be the first matter that gets taken up as soon as the judges do get seated. So, just to explain, as we were talking about, basically, what the court is going to examine, the question that the court is going to answer specifically has to do with the Special Marriage Act. It will examine the Special Marriage Act that currently says between a man and a woman. It'll examine whether that nomenclature, the words man and woman, can be tinkered with a little bit to include all genders, to include non-binary trans people. So basically, instead of specifying only man and woman, can it say any consenting adult? Effectively, that's the question. But it's a massive, it seems simple, but it's massive because, like Ashok Rakavi pointed out, if the judges decide that, then personal laws, there are lots of other things that get, as soon as you allow, then again, you have to look at the adoption law will need to get tweaked. The surrogacy law will need to get tweaked. Inheritance laws will need to get tweaked. Now, inheritance laws would mean that you'll be entering the personal law, category. Adoption is in the personal law category. Insurance, all of these things that mentions marriage, and everything mentions marriage, right? Your bank account, your passport, everything, your identity, everything mentions marriage. So, it might seem like a small clerical change inside the Special Marriage Act, but the impact that it will have is massive. So the question is the Supreme Court ready to do that for us today? Because what happens after that is that the matter goes before Parliament, and Parliament will have to start changing all these laws one by one, and there will be a series of cases that will come before the High Courts and before Supreme Court to make changes to each of these laws. So every one of these things will then be a separate litigation that comes in before the courts, right? So that's one massive thing to consider. The second thing, and I must say it, is in case the court decides in favor of marriage equality, there's a possibility that Parliament might bring in an ordinance to reverse it. It's within Parliament's ability to sort of flip that over and reverse it. And then this is a 5 judge bench, so then you have to come back with a 7 judge bench. So this could be a more long drawn out, but anything the court gives us today will be a victory, and to be celebrated. So that's what we are waiting for. We're going to find out what exactly the court is giving us. Nikita Coutinho is here. We have people watching from Australia. We have people watching from Canada. Everyone sort of, here with their fingers crossed, hoping that we'll actually get this today. I'm going to just read out some names. We have Krishna S, Jan and Julian, lots of people who are here right now. Ashok, you wanted to come in on something, the whole idea that it might be a longer battle, but if the court gives us a small win or any win at all, will be welcome at this point.
I basically think, can you hear me?
Yes,
Yeah,
yes, loud and clear.
yeah.
Go ahead.
I basically think that we should look for the thin end of the wedge, and then carry on from there. Don't ask for too many things at the same time. You won't get them. It's not a thali where you can take out stuff you don't like. So ask for some sort of equity. For
Mhm.
example,
Ashok, you're on mute again.
Yeah, your system seems to be taking you on mute a lot. Yeah, I'm going to read out some messages in the meantime. We have someone called Ryan who says, please tell Zainab she's amazing and she's done so much for her with her petitions. We're all super grateful to her for her work. Zainab, that message from Ryan for you. Devansh says, don't worry, guys. Even if it comes in our favor or doesn't, we will never stop being resilient. I think that's a beautiful message at this point. Damien Gonzalez says, hoping for the best. Sneha says, I couldn't sleep through the night. Priyanka says, huge expectations from our judges today for taking a positive step towards equality and inclusion. Devansh Jain, like I said we're going to continue to fight. Someone's watching from Indonesia. Priyanka is watching from Australia. Ankul says, being a gay person, I haven't slept for 24 hours. Hopefully, you'll be able to sleep soundly after this. Lost Boy saying, being late is normal. No, it's possible, that they're just putting final touches on something. There's a lot of procedure that happens in court that we don't fully we don't fully know all of the things before the judges come and sit down. Um, Let me see what else do we have here. So, So obviously, there's going forward, there will be a lot of things to actually break down and understand different laws that will need to be modified. Zainab, like Ashok was saying, we shouldn't be asking for too much at this point. Ask for like the thin end of the wedge. You could just put your foot in. Once you get your foot in, and then after that, you can start asking for more. But even the smallest wedge at this point seems massive, doesn't it?
Totally agree with what you just said, Faye. I think there are some of us who are very cautious in terms of how the bench approaches the topic, but we also are mindful of the fact that there are going to be as many amendments as required in the law system to be able to accommodate marriage equality for all. But I would say people who have taken a stand, who managed to reach the court, who demonstrated courage, have asked, because we are not just one set of petitions. It is one very diverse set of petitions. And whether it is trans people like me, Akai, etc., whether it is cisgendered gay couples, etc., the fact is that all of us are looking at this piece of judgment. And for all of those listening, and I must tell you this one thing, and I say this as someone who's been involved in legal struggles for about the last 15 years or so. Hope is not the condition or the cause of action. Hope is the consequence of action. When we started off with filing this case in Delhi High Court, we knew that there is a possibility of losing it. We knew that we were prepared for the long haul of going to Supreme Court, and then also going on with the streets to convert what is being said in the Supreme Court to actually what it means for us as commoners. So please have hope, folks, and continue the engagement and the fight, because this is going to change the way we all see and how the way people perceive us.
So, and I asked you this question before. I'm going to ask you again, Zara. Obviously, the best would be if the court said that yes, from tomorrow, all non-binary couples can get married. But if you were to, what would be the minimum you would expect today? What sort of a declaration do you think is most
आप नाश्ता
likely?
करेंगे ना सर? हाँ
See,
कर लीजिए नाश्ता, फिर मैं बाइक
I
करता
would
हूँ.
basically just want to look at a basic minimum thing of being able to register a partnership, even if it's not full-fledged marriage
Yeah.
equality, to be able to at least have some semblance of a civil partnership that gives us the rights within the marriage to start off with. Whether we get the right to marry and it is fundamentally recognized in the eyes of law, we will see when the judgment unfolds itself. But my basic expectation from this court of law is to at least get to an institution
Right.
of partnership.
Okay.
Yes.
So Zara, I want to interrupt you. Forgive me. The judges have now assembled. We're going to listen in our audience. Those are the judges that have come in. You pick up the audio from Supreme Court, please.
Chalo. Yeah. I can't hear a thing, Faye. पूरा सुप्रीम कोर्ट बेंच
If we don't have audio on this.
rights to be beyond the scope of the state's regulation. The state must assess if its interest in democratizing the private space overrides the interests of privacy in a given situation. In pursuance of the power conferred by Articles 245 and 246, read with entry 5 of the concurrent list, Parliament has enacted laws creating and regulating socio-legal institution of marriage. The state legislatures have made amendments to such laws with the assent of the President, since the subject of marriage is in the concurrent list. The petitioners seek that the court recognize the right to marry as a fundamental right. As explained above, this would mean that even if Parliament and the state legislatures have not created an institution of marriage in exercise of their powers under entry 5 of the concurrent list, they would be obligated to create an institution because of the positive postulate encompassed in the right to marry. This argument cannot be accepted. As explained in the previous section, the state through the instrument of law characterizes marriage with two constituent elements, the expressive component and the material component. Marriage may not have attained the social and legal significance it currently has if the state had not regulated through law. Thus, while marriage is not fundamental in itself, it may have attained significance because of the benefits which are realized through regulation. If the court finds that a provision is contrary to Part 3 of the Constitution, it shall declare that it is void, or read it down by deleting phrases, or read words in by adding or substituting phrases to save it from being declared void. If in the present batch of petitions, this court holds that Section 4 of the Special Marriage Act is unconstitutional because it is under-inclusive to the extent that it excludes, by implication, marriage between same-sex couples, the court would either strike down Section 4 of the SMA or follow the workability model submitted by the petitioners. If the court follows the first approach, the purpose of a progressive legislation such as the SMA would be lost. The SMA was enacted to enable persons of different religions and castes to marry. If the SMA is held void for excluding same-sex couples, it would take India back to the pre-independence era, where two persons of different religions and castes were unable to celebrate love in the form of marriage. Such a judicial verdict would not only have the effect of taking the nation back to the era when it was clothed in social inequality and religious intolerance, would also push the courts to choose between eradicating one form of discrimination and prejudice at the cost of permitting another. If this court takes the second approach and reads words into the provisions of the SMA and provisions of other allied laws such as the Indian Succession Act and Hindu Succession Act, it would in effect be entering into the realm of the legislature. The submissions of the petitioners indicate that this court would be required to extensively read words into numerous provisions of the Special Marriage Act and other allied laws. The court is not equipped to undertake an exercise of such wide amplitude because of its institutional limitations. This court would in effect be redrafting the laws in the garb of reading words into the provisions. It is trite law that judicial legislation is impermissible. We are conscious that the courts usually first determine whether if the law is unconstitutional and then proceed to decide on the relief. However, in this case, an exercise to determine whether the SMA is unconstitutional because of under-inclusiveness would be futile because of the limitations of this court's power to grant a remedy. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine. Parliament has access to varied sources of information and represents in itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the CARA circular. Page 153, page correction. The understanding of the Constitution, then I've said the goal of self-development and what it means to be human. This understanding of the Constitution is substantiated on a reading of Part 4 of the Constitution. To illustrate, Article 38 states that the state shall strive to promote the welfare of people. Then I've referred to Article 42 and Article 47. The Constitution, through both positive and negative postulations, inter alia capacitates citizens in their quest to develop themselves. Such capacity building enables them to achieve their full potential in both the private and the public space and to be happy. The Indian Constitution, unlike, say, the South African Constitution, does not expressly provide that the Constitution seeks to improve the quality of life and free the potential of each person. However, such an understanding can be gleaned from the provisions of Part 3 and Part 4. Thus, one of the purposes of the rights framework is to enable the citizenry to attain the goal of self-development. Humans are unique in many respects. We live in complex societies, are able to think, communicate, imagine, strategize, and to do more. However, that which sets us apart from other species does not by itself make us human. These qualities are necessary elements of our humanity, but taken alone, they paint an incomplete picture. In addition to these qualities, our ability to feel love and affection for one another makes us human. We may not be unique in our ability to feel the emotion of love, but it is certainly a fundamental feature of our humanity. We have an innate need to see and to be seen, to have our identity, emotions, and needs fully acknowledged, recognized, and accepted. The ability to feel emotions such as grief, happiness, anger, and affection, and the need to share them with others makes us who we are. As human beings, we seek companionship, and most of us value abiding relationships with other human beings in different forms and capacities. These relationships may take many forms: the natal family, cousins and relatives, friends, romantic partnerships, mentors, or students. Of these, the natal family, as well as the family created with one's life partner, form the fundamental groups of society. The need and ability to be a part of a family forms a core component of our humanity. These relationships, which nourish the emotional and spiritual aspects of our humanity, are important in and of themselves. Further, they are as important to self-development as the intellectual and eventually financial nourishment we receive through education. Self-development cannot be measured solely in terms of educational qualifications and financial capabilities. Such a description is to forget what makes us human. It is insufficient if persons have the ability and freedom to form relationships unregulated by the state. For the full enjoyment of such relationships, it is necessary that the state accord recognition to such relationships. Thus, the right to enter into a union includes the right to associate with a partner of one's choice, according recognition to the association, and ensuring that there is no denial of access to basic goods or services, which is crucial to achieve the goal of self-development. On the other hand, the state could indirectly infringe upon the freedom when it does not create sufficient space to exercise that freedom. A formal associational status or recognition of the association is necessary for the free and unrestricted exercise of the freedom to form intimate associations. Needless to say, there may be reasonable restrictions on this right. However, other than legally valid and binding restrictions, the right to intimate associations must be unrestricted. The state, by not endorsing a form of relationship, encourages certain preferences over others. In a previous segment of this judgment, we have discussed the tangible and intangible benefits of recognizing relationships in the form of marriage. While the tangible benefits of marriage are traceable to the content of law, the intangible benefits are secured merely because the state recognizes the relationship through the instrument of law. Intangible benefits in the form of expressive advantages exist irrespective of the content of the law. Even if the law does not grant any special material benefits to a relationship, the relationship would still be considered to be legitimate in the eyes of society. The freedom to choose a partner and the freedom to enjoy their society, which are essential components of the right to enter into a union, and the freedom of intimate association, would be rendered odious if the relationship were to be discriminated against. For the right to have real meaning, the state must recognize a bouquet of entitlements which flow from an abiding relationship of this kind. A failure to recognize such entitlements would result in systemic discrimination against queer couples. Unlike heterosexual couples who may choose to marry, queer couples are not to marry by statute. To remedy this, during the course of the hearing, the Solicitor General of India made a statement that a committee chaired by the Cabinet Secretary will be constituted to set out the rights which will be available to queer couples and unions. The committee shall set out the scope of the benefits which accrue to such couples. I've traced the right to form unions through a variety of provisions of the Constitution, and I'll refer to Article 19(1)(e) among other things. Citizens of India have the right to settle in any part of the territory of India in terms of Article 19(1)(e). They, like all other citizens, may exercise this right in two ways. First, they may build their lives in a place of their choosing in accordance with law, either by themselves or with their partner. They may reside in that place permanently, subject to other reasonable restrictions, including those intended to protect the rights of tribal communities. This right is uniquely significant to persecuted groups, such as queer persons, intercaste couples, or interfaith couples, who migrate from their hometowns to other places in the country, including cities. And second, they may settle down with another person by entering into a lasting relationship with them. In fact, this mode of the exercise of the right under Article 19(1)(e) is encompassed by the first mode, because to many people, building a life includes choosing their life partner. Hence, the right to enter into a union is also grounded in Article 19(1)(e). Article 21 is available to all persons, including queer persons. Article 21 encompasses the rights to dignity, autonomy, and privacy. Each of these facets animates the others. It is not possible to speak of the right to enter into a union without also speaking of the right to intimacy, which emanates from these rights. Page 170 note kar do. These rights demand that each individual be free to determine as long as their actions are not barred by law. Choosing a life partner is an integral part of determining the course of one's life. Most people consider this decision to be one of the most important decisions of their life, one which defines their very identity. Life partners live together, spend a significant amount of time with one another, merge their respective families, create a family of their own, care for each other in times of sickness, support one another, and much more. Hence, the ability to choose one's partner and to build a life together goes to the root of the right to life and liberty under Article 21. Undoubtedly, many persons choose not to have a life partner, but this is by choice and not by a deprivation of their agency. The law constrains the right to choose a partner in certain situations, such as when they are within prohibited degrees of relationships or are in a consanguineous relationship. All persons, including members of the queer community, have the right to judge the moral quality of the actions in their own lives, and having judged their moral quality, have the right to act on their judgment in a manner they see fit. This attribute is, of course, not absolute and is capable of being regulated by law. In the segment of this judgment on the right to life and liberty, this court noticed that the meaning of liberty is, at its core, the ability to do what one wishes to do and be who one wishes to be in accordance with law. All persons may arrive at a decision regarding what they want to do and who they want to be by exercising their freedom of conscience. They may apply their sense of right and wrong to their lives and live as they desire in accordance with law. Some of the decisions, the moral quality of which they will judge, including the decision on who their life partner will be and the manner in which they will build their life together. Each individual is entitled to decide this for themselves in accordance with their conscience. This court has recognized that equality demands that queer persons are not discriminated against. An abiding cohabitational relationship includes within its fold a union of two individuals, cannot be discriminated against on the basis of sexual orientation. Material and expressive entitlements which flow from a union must be available to couples in queer unions. Any form of discrimination has a disparate impact on queer couples who, unlike heterosexual couples, cannot marry under the current regime. When Article 15 is read in a broader manner indicated above, the word sex in Article 15 takes within its meaning sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because sex is used as a marker of identity. The word sex cannot be read independent of the social and historical context. Thus, sex in Article 15 includes within its fold other markers of identity which are related to sex and gender, such as sexual orientation. Thus, a restriction on the right to enter into a union based on sexual orientation would violate Article 15 of the Constitution. The gender of a person is not the same as their sexuality. A person is a transgender person by virtue of their gender identity. A transgender person may be heterosexual or homosexual, or of any other sexuality. If a transgender person is in a heterosexual relationship and wishes to marry their partner, and if each of them meets the other requirements set out in the applicable law, such a marriage would be recognized by the laws governing marriage. This is because one party would be the bride or the wife in the marriage, and the other party would be the bridegroom or the husband. The laws governing marriage are framed in the context of a heterosexual relationship. Since a transgender person can be in a heterosexual relationship, like a cis male or a cis female, a union between a trans woman and a trans man, or a trans woman and a man, or a trans man and a woman can be registered under the marriage laws. The transgender community consists of inter alia transgender men and transgender women. A transgender man has the right to marry a woman under the laws governing marriage in the country, including personal laws. Similarly, a transgender woman has the right to marry a man. A transgender man and a transgender woman can also marry. Intersex persons who identify as a man or a woman and seek to enter into a heterosexual marriage would also have a right to marry. Any other interpretation of the laws governing marriage would be contrary to Section 3 of the Transgender Persons Act and Article 15 of the Constitution. Now I've gone to the CARA regulations, Regulation 5.3 of the adoption regulations, and I've said that Regulation 5.3 of the adoption regulations exceeds the scope of the JJ Act. However, Regulation 5.3 of the adoption regulations bars unmarried partners from being prospective adoptive parents. These regulations only permit persons to adopt in an individual capacity and not jointly as an unmarried couple. Regulation 5.2 states that every person, irrespective of whether they are married or not, be able to be prospective adoptive parents. The subsequent criteria in Clause A, that is the requirement for the consent of both spouses if they are married, does not exclude an unmarried couple from adopting. It only states that if a couple is married, then the consent of both the parties shall be secured. However, Regulation 5.3 in express terms excludes unmarried couples from adopting by prescribing the condition that the couple must have been in 2 years of a stable marital relationship. Page 210. As observed in the previous paragraph, the JJ Act does not, the Juvenile Justice Act does not preclude unmarried couples from adopting. Though Section 57 of the Act grants CARA the power to prescribe additional criteria, the criteria must not exceed the scope of the legislative policy. Neither the general principles guiding the JJ Act nor Section 57 in particular preclude unmarried couples from adopting a child. In fact, all the other criteria ensure the child's best interest. The U.S. proved that precluding unmarried couples from adopting a child, even though the same people are eligible to adopt in their individual capacity, is in the child's best interest. Thus, CARA has exceeded its authority by prescribing an additional condition by way of Regulation 5.3, which is contrary to the tenor of the Juvenile Justice Act and Section 57 in particular. The adoption regulations use marriage as a yardstick to classify couples. There is an intelligible differentia in using marriage as an indicator to classify couples in the sense that married couples can easily be distinguished from unmarried couples. However, the differentia does not have a rational nexus with the object sought to be achieved by the CARA regulations, which is to ensure that the best interest of the child is protected. Placing a child in a stable family is undoubtedly in pursuance of a child's interest. However, the respondents have not placed any data on the record to support their claim that only married relationships can provide stability. It is true that separating from a married partner is a cumbersome process when compared to separating from a partner with whom a person is in a live-in relationship. This is because separation from a married partner is regulated by the law, while live-in relationships are unregulated by law, other than for the limited purposes of domestic violence. For instance, the law deters a person from securing a divorce immediately by prescribing conditions such as a 6-month waiting period after a petition for divorce by mutual consent is filed. Merely because a marriage is regulated by the law, it cannot be assumed that marriage alone or that every marriage accords stability to a relationship. Similarly, it cannot also be inferred that the couples who are not in a married relationships are not serious about the relationship. The stability of the household depends on various factors, such as the effort and involvement of the partners in establishing and running a household, creating a safe space at home, creating a healthy work-life balance, and a household where mental, physical, and emotional violence is not inflicted on one another. There is no single form of a stable household. There is no material on the record to prove the claim that only a married would be able to provide stability to the child. In fact, this court has already recognized the pluralistic values of our Constitution, which guarantee a right to different forms of association. Regulation 5.3, though facially neutral, indirectly discriminates against atypical unions, such as the relationship between non-heterosexual partners, which have not been recognized by the state. Queer marriages have not been recognized by the state, and queer persons in atypical unions cannot yet enter into a marriage which is recognized by the state. Though the additional criteria prescribed by the adoption regulations would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the to meet the eligibility criteria for adoption However, this option is not available to queer couples. When Regulation 5.3 is understood in the light of this position, a queer person who's in a relationship can only adopt in an individual capacity. This exclusion has the effect of reinforcing the disadvantage already queer community. The law cannot make an assumption about good and bad parenting based on the sexuality of individuals. Such an assumption perpetuates a stereotype based on sexuality that only heterosexuals are good parents and all other parents are bad parents, which is prohibited by Article 15. This assumption is not different from the assumption that individuals of a certain class or caste or religion are better parents. In view of the above observations, the adoption regulation is violative of Article 15 for discriminating against the queer community. According to the adoption regulations, unmarried couples cannot jointly, though the additional criteria prescribed by the CARA circular would also affect a heterosexual person's eligibility to adopt a child. It would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to the unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child, marrying the criteria for adoption. This is not an option for queer couples. When the CARA circular is read in the light of this legal position, a person of the queer community would be forced to choose between their wish to be an adoptive parent and their desire to enter into a partnership with a person they feel love and affinity with. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. For these reasons and the reasons recorded in section D so and so, the CARA circular is violative of Article 15 of the Constitution. I've addressed myself to my disagreement with the scholarly judgment of my learned brother, Justice Bhatt. My learned brother, of Article 19(1)d, is of a law which casts a duty on the state through roads. A citizen cannot approach the court and seek the construction of a road to enforce the right to move freely. The opinion of my learned brother fails to have noted the judgment of a 3-judge bench of this court in state of Himachal Pradesh versus Umed Ram Sharma. I'll not read the rest of that. Contrary to what is stated in the judgment of Bhajje, the directions in my judgment do not require the state to create a social or legal status or a social institution. The directions are with a view to recognizing the choice that a person makes for themselves when they choose another to be their partner for life. Directions seek to make that choice a meaningful one. Nowhere do they create an institution of any kind. Rather, they give effect to the fundamental rights in Part 3 of the Constitution. This is the mandate of this court under Article 32, which says that the Supreme Court shall have the power to issue directions or orders or writs for the enforcement of any of the rights conferred by this part. Forthcoming to my detailed exposition of this court under Article 30, in section D1 of my judgment. In fact, Justice Bhatt himself recognized that courts often enable and oblige the state to take measures. My learned brother also arrives at the conclusion that the state is indirectly discriminating against the queer community, but fails to exercise the power vested in this court by Article 32 to alleviate this discrimination in any way. This court is not through judicial diktat creating a legal regime exclusively for persons of the queer community, but merely recognizing the duty of the state to recognize the entitlements flowing from the right to choose a life partner. Page 234. The judgment of my learned brother contradicts itself when he holds that the SMA is not discriminatory by relying on its object on the one hand, and that the state has indirectly discriminated against the because it is the effect and not the object on the other. My learned detail the deprivation, exclusion, and discrimination faced by the queer community. In effect, he firstly recognizes that they have a right not to be discriminated against, and secondly holds that the actions of the state have the effect of discriminating against them. However, he does not take the step which logically flows from such a ruling, which is to pass directions to obviate such discrimination and ensure the realization of the rights of the queer community. I cannot bring myself to agree with this approach. The realization of a right is effectuated when there is a remedy available to enforce it. The principle of ubi jus, ibi, that is an infringement of a right has a remedy, which has been applied in the context of civil law for centuries, cannot be ignored in the constitutional context. Absent the grant of remedies, the formulation of doctrines is no more than judicial platitudes. In view of the deeming fiction created by Section Adoptions and Maintenance Act 19 and Section 63, an adopted child is a legitimate child of the adopting couple. The manner of determination of legitimacy prescribed by Section 112 of the Indian Evidence Act shall not apply in view of the deeming fiction created by Section 12 of the Hindu Adoptions and Maintenance Act and Section 63 of the JJ Act. Thus, all the benefits which are available under the law to a legitimate child who has been validly adopted of a married couple will equally be available to the legitimate child of an unmarried couple. For example, Section 20 of the Hindu Adoptions Act, which provides that a Hindu is to maintain their children, does not make any distinction between a legitimate child of a married and unmarried couple. Succession law in India does not differentiate between the child of a married and unmarried couple if the child has been adopted by following the due process of law. Further, the breakdown of the relationship of an unmarried couple will not lead to a change in applicable law because the child will continue to be a legitimate child even after the breakdown of the relationship. It is therefore unclear consequences referred to are. Further, has also failed to address whether Regulation 5.3 is discriminatory for distinguishing between married and unmarried couples for the purpose of adoption and for the disproportionate impact that it has on the members of the queer community, while simultaneously holding that the state cannot on any account make regulations that are facially or indirectly discriminatory on the ground of sexual orientation. Now I'll pronounce my directions. The first part of my directions are directions to obviate discrimination. Counsel for the petitioners and some counsel for the respondents advanced extensive submissions on the various forms of violence and discrimination the state machinery inflict upon the queer community and especially queer couples. This has been discussed in detail in the prefatory part of the judgment. Counsel sought directions to obviate such violence and discrimination. Now my directions. A. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or garima grahs in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure, either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offense. The police must first determine if the person is an adult If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect. Conclusions and orders of enforcement. In view of the discussion above, the following are the conclusions. This court A. This court is vested with the authority to hear this case. Under Article 32, this court has the power to issue directions, orders, or writs for the enforcement of the rights in Part 3. B. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. D. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing a relationship in the form of marriage, the state grants material benefits exclusive to marriage. E. The state has an interest in regulating the intimate zone to democratize personal relationships. F. The issue of whether the Constitution recognized the right to marry did not arise before this court in Justice K.S. Puttaswamy, 9 judges, Shafin Jahan, and Shakti Vahini. G. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain. I. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. J. In Article 15.1, the word sex must be read to include sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because the word sex is used as a marker of identity, which cannot be read independent of the social and historical context. K. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. L. The decisions in Navtej and Justice K.S. Puttaswamy, 9 judges, recognize the right of queer couples to exercise the choice to enter into a union. This relationship is protected from external threat. Discrimination on the basis of sexual orientation will violate Article 15. M. Transgender persons in heterosexual relationships have the right to marry under existing law, including personal laws which regulate marriage. N. Intersex persons who identify as either male or female have the right to marry under existing law, including personal laws which regulate marriage. O. The state must enable the LGBTQ community to exercise its rights under the Constitution. Queer persons have the right to freedom from coercion from their natal families, agencies of the states, including the police and other persons. P. Unmarried couples, including queer couples, can jointly adopt a child. Regulation 5.3 of the adoption regulations is ultra vires the Juvenile Justice Act, Articles 14 and 15. Regulation 5.3 is read down to exclude the word marital. The reference to a couple in Regulation 5 includes both married and unmarried couples as well as queer couples. The principle in Regulation 5.2a that the consent of spouses in a marriage must be obtained if they wish to adopt a child together is equally applicable to unmarried couples who seek to jointly adopt a child. However, while framing regulations, the state may impose conditions which will subserve the best interest and welfare of the child in terms of the exposition in this judgment. Q. In view of the interpretation of Regulation 5.3 of the adoption regulations, the issue of whether the CARA circular disproportionately impacts the queer community no longer arises. R. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law. And S, we record the assurance of the Solicitor General that the Union Government will constitute a committee chaired by the Cabinet Secretary for the purpose of defining and elucidating the scope of the entitlements of queer couples who are in unions. The committee shall include experts with domain knowledge and experience in dealing with the social, psychological, and emotional needs of persons belonging to the queer community, as well as members of the queer community. The committee shall, before finalizing its decisions, conduct wide stakeholder consultation amongst persons belonging to the queer community, including persons belonging to marginalized groups, and with the governments of the states and union territories. The committee shall, in terms of the exposition in this judgment, consider the following. 1. Enabling partners in a queer relationship, A, to be treated as a part of the same family for the purposes of a ration card, and B, to have the facility of a joint bank account with the option to name the partner as a nominee in case of death. 2. In terms of the decision in Common Cause versus Union of India, as modified by Common Cause versus Union of India 2, medical practitioners have a duty to consult family or next of kin or next friend in the event of patients who are terminally ill and have not executed an advance directive. Parties in a union may be considered family for this purpose. 3. Jail visitation rights and the right to access the body of the deceased partner and arrange the last rites. And 4. Legal consequences such as succession rights, maintenance, financial benefits such as under the Income Tax Act 1961, rights flowing from employment such as gratuity and family pension and insurance. The report of the committee chaired by the Cabinet Secretary shall be implemented at the administrative level by the Union Government and the governments of the states and the Union territories. This is what.
I've had the benefit of the exhaustive and erudite judgment of Chief Justice Chandrachud, which enumerates the prevalence of these relationships in history, the constitutional recognition of the rights to form union, in other words, what I categorize as civil unions, and the necessity of laying down guidelines to protect the non-heterosexual unions. In a way, this is a step forward from the decriminalization of private consensual sexual activities. However, the subject matter itself persuaded me to pen down a few words while broadly agreeing with my brother's judgment. I've dealt with the historical prevalence of non-heterosexual unions. I've said that it is no longer res integra, that the duty of a constitutional court is to uphold the rights enshrined in the Constitution and not to be swayed by a majoritarian tendency or popular perceptions. This court has always been guided by constitutional morality and not by social morality. Pluralistic social fabrics has been an integral part of the Indian culture. I've referred to some observations from the Rig Veda and the Somdas Pratya Sargra. And then I've said the significant aspect is that the same-sex union were recognized in antiquity not simply as unions that facilitate sexual activity, but as relationships that foster love, emotional support, and mutual care. I've referred to some traditions in the Sufi traditions. Then I've said the marriage as an institution developed historically and served various social functions. It was only later in its long history that it came to be legally recognized and codified. However, these laws regulated only one type of social historical union, that is the heterosexual union. It would thus be misconceived to claim that non-heterosexual unions are only a facet of modern social milieu. The objective of penning down this section is to provide perspective on the existence of non-heterosexual unions, despite continued effort towards their erasure by heteronormity of majority. The non-heterosexual unions are entitled to protection under a constitutional scheme. I've referred to the necessity of recognizing what I've categorized as civil unions. The judgment of the Chief Justice notes the right to form union is a feature of Article 19 and 21. Therefore, the principle of equality enumerated under Article 14 and 15 demand this right to be available to all regardless of sexual orientation and gender. Having recognized this right, this court has taken on board the statement of the learned Solicitor General to constitute a committee to set out the scope of the benefits available to such union. I agree with the Honorable Chief Justice. I have referred to the Special Marriage Act and discussed the statement, object, and reason therefore from the Above, the SMA postulates a special form of marriage available to any person in India, irrespective of faith. Therefore, SMA provides a secular framework for solemnization and registration of marriage. It is here that I respectfully disagree with my brother Justice Bhatt that the sole intention of SMA was to enable marriage of heterosexual couples exclusively. To my mind, the stated objective of SMA was not to regulate marriages on the basis of sexual orientation. This cannot be so, as it would amount to conflating the differentia with the objective of the statutes. Although substantive provisions of SMA confer benefits only on heterosexual relationships, this does not automatically reflect the objective of the statutes. I've said if the intent of the SMA was to facilitate interfaith marriages, then there would be no rational nexus to the classification it makes of excluding not heterosexual relationships. Then I've referred to the regulation of only heterosexual marriages would not be legitimate state objective, more so in cases where ex officio protected categories under Article 15(1) of the Constitution. However, I recognize, therefore, I have said that if this was so, the SMA would be violative of Article 14. However, I recognize that there are multifarious interpretative difficulties in reading the SMA to include marriage between non-heterosexual relationships. These have been enumerated in a significant detail in the opinions of both the Honorable Chief Justice and Justice Bhatt. I also agree that the entitlements devolving from marriage are spread across the proverbial spider web of legislations and regulations. As rightly pointed out by the learned Solicitor General, tinkering with the scope of marriage under SMA Act can have a cascading effect across these disparate laws. In fact, the presence of this web of statutes show that discrimination under SMA is but one example of a larger, more deeper form of social discrimination against non-heterosexual people that is pervasive and structural in nature. Ordinarily, such an intensive form of discrimination should require keener and more intensive judicial scrutiny, but then that's the statute. And I say non-heterosexual unions and heterosexual unions marriages ought to be considered as two sides of the same coin, both in terms of recognition and consequential benefits. The only deficiency at present is the absence of a suitable regulatory framework for such unions. I refer to Navtej's view. I believe this movement presents an opportunity of reckoning with this historical injustice and casts a collective duty upon all constitutional institutions to take affirmative steps to remedy the discrimination. The next step in due course would be to create an edifice of governance that would give meaningful realization to the rights to enter into the union, whether termed as marriage or as unions. Then I referred to the interpreting statutes using constitutional principles. As noted above, the benefits pertaining to marriage are spread across several incidental legislation and regulations. These statutes presently do not explicitly extend to civil unions. However, now that we have recognized the right to enter into civil union, such statutes must be read in a manner to give effect to this right, together with the principles of equality and non-discrimination under Article 14 and 15. In other words, statutory interpretations must be in consonance with constitutional principles that are enumerated by this court. Needless to say, this should not detract from the committee's task of ironing out the nitty-gritties of the entitlement of civil union. This exercise is necessary to foster a greater coherence within the legal system as a whole, both intercede the statutes and between statutes and the constitution. I referred to some views from the German courts and the South African courts have dealt with these issues. Then I've referred to the interpretation on issue of public policy. I've said this technique of reading constitutional values should be used harmoniously with other canons of statutory interpretation. I've gone on to the need for anti-discrimination law. I wholeheartedly in agreement with the opinion of Honorable Chief Justice that there is need for separate anti-discrimination law, which inter alia prohibits discrimination on the basis of sexual presentation. Presently, there are several laws that have anti-discrimination aspects. However, they are fragmented and may fail to capture the multitudinous forms of discrimination. Another compelling reason for a law that places a horizontal duty of anti-discrimination is provided by the spirit of Article 15, which prohibits discrimination both by the state and private actors. My suggestions for anti-discrimination law are as follows. First, such law should recognize discrimination in an intersectional manner. This is to say, in assessing any instance of discrimination, the court cannot confine itself to a singular form of discrimination. Instead, discrimination must be looked at as a confluence of factors, as identities and individual instances of oppression that intersect and create a distinct form of disadvantage. Discrimination laws can only be effective if they address the types of inequalities that have developed in a given society. Refer to the equal rights to equal love. The principle of equality mandates the non-heterosexual unions are not excluded from the mainstream of socio-political framework. However, the next step would be to examine the framework itself. I believe the recognition of non-heterosexual union can challenge culturally ordained gender roles, even in heterosexual relationships. I've given some examples of this. Need not read it here. You can see it. In a non-heterosexual union, duties, obligations are primarily dictated by cultural ordained gender norms. Legal recognition aids social acceptance, which in turn increases the queer participation in public space. Through the medium of legal recognition, queer persons will have a greater opportunity to be seen and heard in ways not previously possible. Queer expression will help facilitate an expansive social dialogue cutting across communities and generations. This dialogue will help us reimagine our relationships in a manner that emphasizes the values such as mutual respect, companionship, and empathy. Conclusion. Is this end where we have arrived? The answer must be an emphatic no. Legal recognition of non-heterosexual unions represents a step towards the marriage equality. At the same time, marriage is not an end itself. Our Constitution contemplates a holistic understanding of equality, which applies to all spheres of life. The practice of equality necessitates acceptance and protection of individual choices. The capacity of non-heterosexual couples for love, commitment, and responsibility is no less worthy of regard than the heterosexual couples. Let us preserve as long as it does not infringe on the rights of the others. It is my life in the song by Bon Jovi.
Having had the benefit of reading the draft and the revised opinions circulated by the learned Chief Justice, we find it necessary to pen our reasoning and conclusions in this separate judgment. The learned Chief Justice has recorded in detail the submissions by counsel and claims made. They therefore do not require iteration. Similarly, the sections addressing the Union government's preliminary objections, that is the discussion on the court's authority that queerness is a natural phenomenon that is neither urban nor elite, are parts we have no hesitation in agreeing with. However, we do not agree with the conclusions arrived by the learned Chief Justice and the directions issued. We do not agree with certain premises and conclusions that he has recorded. They are, one, that there exists no fundamental. We do agree with the premises and conclusions that he has recorded. They are that there exists no fundamental right to marry under the Constitution, that the Special Marriage Act is neither unconstitutional nor can it be interpreted in such a manner as to enable marriage between queer persons, and that transgender persons in heterosexual relationships have the right to solemnize marriage under the existing legal frameworks. We have briefly highlighted our main points of agreement and reasoned in more detail those aspects with which respectfully we cannot persuade ourselves to concur. We had the benefit of perusing the concurring opinion of Justice Narasimha. We endorse those observations and conclusions fully. The reasoning and conclusions shall be read as supplementing that of the present judgment. For long periods in societies, many societies, the choice of the matrimonial was not free. It was bound by social constraints. Much of the time, marriage was seen as an institution meant for procreation and sexual union of spouses. In most societies, marriage had cast roles for the spouse. They were fairly inflexible, with men controlling most decisions and women placed in a subordinate position with little or no voice. And for the longest time, no legal authority, autonomy, or agency. For millennia, custom, tradition, and law subordinated wives to husbands. Notions of equality of partners or their roles were uncommon, if not totally unheard of. All these underwent radical change. Legislative activities aimed at bringing about gender parity through prohibiting prevailing practices that further inequality and sometimes even criminalize certain customs, resulting in legislations such as Equal Remuneration Act, the Dowry Prohibition Act, introduction of provisions in the criminal law which gave teeth to such provisions, such as Section 498, Section 113 A and B of the Evidence Act, etc. Other practices aimed at realization of social goals and furthering the mandate of Article 15.3 in respect of children, such as the right to free universal education under Article 21A, the Right to Free Education on Act 2009, the Child Labor Prohibition and Regulation Act 1986, the POXO, what we call as POXO, the Juvenile Justice Act, etc. In all these, the Parliament or concerned legislatures donned the role of reformers and furthered the express provisions of the Constitution, enjoining state action in furtherance of Articles 15.2, 15.3, 17, 23, and 24. Marriage has historically been a union solemnized as per customs, a personal law tracing its origin to religious texts. Legislative activity in the personal law field so far has been largely, though not wholly, to codify prevailing customs and traditions and regulating them only where needed. The instances that stand out are the enactment of the Succession Act, the Hindu Women's Right to Property Act, 1937, the Hindu Marriage Act, the Adoptions and Maintenance Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Indian Divorce Act. As amended, the Muslim Personal Law Sharia Application Act, and the Anand Marriage Act, 1909. These laws mostly codified traditions and customs which existed, and also, to an extent, regulated marriages and succession laws. They also sought to introduce reforms. For the first time, monogamy was enacted as a norm applicable to all Hindus. Likewise, the option of divorce was enacted together with grounds on which other remedies, such as judicial separation and maintenance, could be sought. Further, the minimum age of marriage was also enacted through provisions in various personal laws and enforced through the Prohibition of Child Marriage Act. Thus seen that two kinds of legislations have regulated marriage. The first, like SMA, HMA, the Hindu Disabilities Removal Act, and the Hindu Widows Remarriage Act, removed barriers and enabled exercise of meaningful choice, especially to women. The second kind of laws are those which enacted restrictive guidelines, essentially to further an orderly society or to protect women, define minimum age for marriage, child marriage restraint, marriage of individuals within prohibited degrees of relationships, etc. Whereas some restrictions, in a sense, codified and recognized existing customs, such as being enacted by enacting prohibited degrees of relationships, the rule against insanity, rules enabling declaration of nullity or divorce on ground others were meant to further interests of women and children. Such reforming and codification, however, did not cover the entire field. For instance, in the field of succession and inheritance, the Hindu Succession Act enacts only certain broad features, leaving untouched the rights of various communities and sections of Hindus to work out their rights in succession to joint family and co-parcenary property. And this unwritten codified law is enforced not only in regard to inheritance, but also in the field of taxation. Likewise, the law accommodates and accords primacy to customs. Similarly, also recognizes customary divorce amongst Hindus. Neither the Hindu Marriage Act nor the Hindu Succession Act apply to members of tribal communities. In the latest three-judgment decision in Revana Siddhappa versus Mallikarjuna, this court clarified that with the enactment of Section 16 of HMA, the legitimacy conferred upon children born of void or voidable marriages would be that they're entitled only to a share in their parents' property, but cannot claim it of their own right, as a consequence of which they cannot seek partition during the lifetime of their parents. The court also held that they cannot claim any rights other than what was expressly provided for. Thus, uncodified law and custom was upheld. The role of the legislature has been to act as a codifier and in many instances not enact or codify existing customs or practices, and wherever necessary intervene in furtherance of Articles 14 and 15.3 to enact laws. Parliament has intervened and facilitated creation of social status, this is marriage through SMA, and enabled the creation of the institution of adoption, which was available amongst only certain communities. These and other legislative interventions are the result of the state interest in reforms or furthering the interests of given communities or persons. For these reasons, we do not particularly subscribe to the characterization of democratizing intimate zones as discussed in the learned Chief Justice's opinion. These outcomes were driven by enacted law. Furthermore, there was state interest which impelled regulation of such relationships, as for instance, ensuring that minimum marriage age for girls. Likewise, there is state interest in regulating what kind of relationships, that is, prohibited degrees of relationship, should be enacted as disqualifications to marriage. Then there is a discussion or summation of the jurisprudence on Article 21 and the various facets which this court has recognized, such as privacy, choice, autonomy, and dignity. Then we move on. The court's intervention in oft-cited decisions on behalf of the petitioners has been to protect citizens or those approaching them against threats of violence. The instances are Shakti Vahini, Lata Singh, Shafin Jahan, Lakshmi Bai Chandragi, etc. These decisions were based on the state's duty to protect citizens and enable the exercise of their individual choice in the face of threats. Other decisions, that is Joseph Shine, Navtej, and Independent Thought, were instances where specific provisions that criminalized or made exceptions to criminal behavior were struck down or read down in the enforcement of fundamental rights. That is Articles 14, 15, and 21. Along the way, Puttaswamy articulated the broadest right to privacy, which embraces within its fold the right to exercise one's choice of a life partner and to lead the life free from external barriers. This court has recognized that marriage is a social institution. As elaborated in Part 1, marriage existed and exists historically and chronologically in all of the senses because people married before the rise of the state as a concept. Therefore, marriage as an institution is prior to the state, it precedes it. The status is still not one that is conferred by the state, unlike the license regime in the US. This implies that the marriage structure exists regardless of the state, which can later utilize or accommodate, but cannot abolish it. Under this view, terms of a marriage are set to a large extent independently of the state. Its source is external. That source defines the boundaries of marriage. This implies that state power to regulate marriage does not sit easy with the idea of marriage as a fundamental right. In attempting to analyze the claim to fundamental right, there are two primarily competing claims about the nature of marriage. One being that the state should exercise more control over marriage to support purposes and perceptions. This is a quotation. And the other, that each individual should have the right to define marriage for themselves. If indeed there is a right to marry, unless it is elevated to a right akin to Articles 17, 23, and 24, which apply to both state and non-state agencies, and are cast in positive, in fact, emphatic terms, it cannot be operationalized. These provisions most emphatically create positive obligations. Likewise, Articles 15.3, 15.4, 15.6, as well as 16.4, 16.6 highlight state interest in creating conditions to further the goal of non-discrimination. Yet the previous decisions of this court have carefully held such provisions to enable the state and in the sense oblige it to take measures, but ruled out court-mandated policies and laws. In our considered opinion, this is not, however, one such case where the court can make a departure from such a rule and require the state to create social or legal status. What is being asked for by the petitioners is state intervention in enabling marriage between queer or non-heterosexual couples. Civil marriage or recognition of any such relationship with such status cannot exist in the absence of a statute. The demand hence is that of a right of access to a publicly created and administered institution. There is a paradox here or a contradiction which runs to the root of the issue and weighs on this court's mind heavily, in that the creation of the institution here depends on state action, which is sought to be compelled through the agency of this court. All decisions relied upon Puttaswamy, Navtej, Shakti Vahini, and Deepika contain broad observations with respect to individuals' choice of their partners and also a reference to non-conventional relationships. Some observations are undoubtedly to be found in these judgments that cannot be referenced to hold that a right to marry automatically flows from the manner of the provisions of Part 3 which the petitioners assert. There cannot, for the above reasons, be a per se assertion that there exists an unqualified right to marry, which requires treatment as a fundamental freedom. We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry. While we agree that there is a right which we characterize as a right to a relationship, which is recognized in Navtej, that the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21, as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and the other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely and express this choice undisturbed in society. Whenever the right to enjoyment of such relationship is under threat of violence or coercion, the state is bound to extend necessary protection. That is the natural consequence of this court's judgments in Navtej, Puttaswamy, etc. If it is agreed that marriage is a social institution with which the state is unconcerned, except to the limited state interest in regulating some aspects of it, does it follow that any section of the society, leaving aside the issue of rights of non-heterosexual couples, which wishes for the creation of a like social institution, or even an entry into a zone which is not popular or otherwise does not fall within the institution of marriage, can seek relief of its creation by court intervention? In the draft circulated by the learned Chief Justice, the reasoning that there is no fundamental right to marry, and thereafter, nevertheless, to proceed to delineate the facets of features which unions other than marriage are deprived of, where it's a closer look. The summation of various rights which such couple is said to be deprived of is used to delineate the contours of the right to enter into a union and justify a positive obligation. There cannot be any doubt that individuals have the choice of their life partners and the right to live the lives they wish to undisturbed. This is the essence of what this jurisprudence of this court has been. That is explanation of the right to life and other rights enumerated or discovered by the interpretive process, privacy, choice, dignity, etc. Repeatedly, the decisions of the court have emphasized on the non-discriminatory and positive content of certain fundamental rights. In fact, the court has underlined the obligations of the state to create conditions conducive to the exercise of the right to equality and to realize fraternity. Refer to the decisions in Thomas and Indira Sani, which expanded the understanding of substantive equality, though without making enabling provisions enforceable by the court. Also, in some decisions, accepted the argument that given the nature of fundamental rights and their evolving content, in many circumstances, it might be necessary for the state to intervene and protect the fundamental right concerned, thus creating an atmosphere conducive for the enjoyment of such right. Lata Singh dealt with honor killings of couples. In Arumugam Sirvai, the issue was virulent caste slurs and violence, which were crimes. The court required administrative and police officials to take strong measures to prevent them. In Shakti Vahini, Shakti Vahini dealt with threats by Khap Panchayats, and the court held that the state is duty bound to protect fundamental rights, and an inherent aspect of Article 21 of the Constitution would be the freedom of choice. The court issued directions. The judgment of the learned Chief Justice propounded a theory of a unified thread of rights, entitlements flowing from it, and how lack of recognition results in deprivation of specified rights under Articles 19 and 25, in addition to Article 21. To the extent that assertion of sexual or gender identity in exercise of free speech association to express manifestations in whatever form are concerned, one cannot join issue. Equally, if by some state process, measures or conduct has been barred from expressing one's choice publicly, the reason that prohibition or order can be tested on grounds enumerated in Articles 19(2) and other grounds. However, when the law is silent and leaves the parties to express choice, Article 19(1)(a) does not oblige the state to enact a law or frame a regulation that enables facilitation of that expression. All judgments of this court were based on effects of laws or policies based on statutory provisions. Equally, in the absence of a legal framework enabling citizens to form a particular kind of association, as for instance, recognition of a limited liability partnership, which was not recognized and given legal status till recently, the court could not have validly created the regime by enabling recognition or regulating such associations. Similarly, the absence of any enacted law which enables facilitation of transport, it is hard to visualize that a citizen can approach the court and seek the construction of a road to enforce the right to travel, or seek the court's intervention to create a network of roads. Likewise, the absence of basic housing. Again, the court, if approached for enforcement of 19(1)(e), call upon the state to create one by either framing a general legislative policy or through law. Furthermore, this court has also recognized that there can be even reasonable restrictions in the acquisition and enjoyment of certain types of properties in many states. Given the nature of rights under Articles 19 and 21, the enjoyment of which are limited to the extent reasonable laws within the bounds of specified provisions, the enact in the legitimate jurisdiction of this court, it would be difficult to translate positive obligations as articulated by the learned Chief Justice's opinion. There is no difficulty about the right of two consenting persons to decide to live together, to cohabit, and create their unique idea of home, unconstrained by what others say. This is the sequitur to Puttaswamy and Navtej. Conduct hitherto criminalized is now permissible. The liberative effect of section 377 being read down is that two individuals, regardless of their sexual orientation, are enabled to live together with dignity and also protected from any kind of violence for living and existing together. Therefore, the right to be left alone, the right to exercise choice, right to dignity and live one's life with the person of one's choice is an intrinsic and essential feature of Article 21. Even if we want to, for argument's sake, recognize an entitlement under the Constitution to enter into an abiding cohabitational relationship or union, in our opinion, it can follow it cannot follow to a claim for an institution. There are almost intractable difficulties in creating, through judicial orders or diktat, a civil right to marry or a civil union, less of the kind the petitioners. Ordering a social institution or rearranging existing social structures by creating an entirely new kind of parallel framework for queer couples would require conception of an entirely different code, a new universe of rights and obligations. This will entail fashioning a regime of state registration of marriage between queer couples, the conditions for a valid and matrimonial relationship amongst them, spelling out eligibility conditions such as minimum age, relationships which fall within prohibited degrees, grounds for divorce, right to maintenance, alimony, etc. The learned chief, as a result, with due respect, we are unable to agree with the conclusions of the learned chief justice with respect to tracing the right to enter into or form unions from the right of freedom of speech and expression, the right to form associations, along with right any other corresponding positive obligation. It is reiterated that all queer couples have the right to relationship and choice of partner, right of cohabitation as an integral part of choice linked to their privacy and dignity. Any further discussion on the rights which consenting partners may exercise is unnecessary. No one has contested that two queer couples have the rights enumerated under 19.1, Articles 19.1a, C, and D, or even the right to conscience under Article 25. The elaboration of these rights to say that the exercise of choice to such relationships renders these meaningful, and that the state is obligated to recognize a bouquet of entitlements which flow from such abiding relationship of this kind is not called for. We therefore respectfully disagree with that part of the learned Chief Justice's reasoning, which forms the basis for some of the final conclusions and directions recorded in his judgment. Agree with the conclusions of the learned Chief Justice with respect to the inapplicability of the SMA, and we also add certain observations. A gender neutral interpretation of SMA and its provisions, much like many seemingly progressive aspirations, may not really be equitable at times and can result in women being exposed to unintended vulnerability, especially when genuine attempts are made to achieve a balance in a social order that traditionally was tipped in favor of cis heterosexual men. The purpose of the terms like wife, husband, man, and women in marriage is to protect a socially marginalized demographic of individuals. For instance, women facing violence by their partner have a right to recourse under the Domestic Violence Act, which assures and is meant to assure that the victims are safeguarded and provided relief. In fact, provisions of SMA for alimony maintenance confer rights to women. Likewise, certain grounds of divorce, conviction of husband for bigamy, rape, etc., entitle the wife additional grounds. Other provisions enact separate degrees of prohibited relationships. Section 4C uses the term husband and wife. There are other provisions which deal with, which specifically used gendered terms. The general pattern of these provisions, including the specific provisions enabling or entitling women certain benefits and the effect of sections 19 to 21A, is that even if for argument's sake, it were accepted that section 4 could be read in gender neutral terms, there are provisions which could apply to such queer couples in such cases would lead to anomalous results rendering the MA unworkable. It is important. Now there's a section that deals with the discriminatory impact on queer couples. It is important to recognize that while the state ipso facto may have no role in the choice of two free-willed individuals to marry, it's characterizing marriage for various collateral and intersectional purposes, such as permanent and binding legal relationships, recognized as such between heterosexual couples only, and no others impacts queer couples adversely. The intention of the state in framing the regulations or laws is to confer benefits to families or individuals who are married. This has the result impacting the queer couples. By recognizing heterosexual couples union and cohabitation as marriages in various laws and regulations, as in employment or nominations in pension, provident fund, gratuity, life and personal accident insurance policies, for credit, particularly joint loans to both spouses, based on their total earning capacity for purposes of receiving compensation in the event of fatal accidents, to name a few, and not providing for non-heterosexual couples results in their exclusion. The individual earned benefits by each partner or both collectively, which would be available to family members, such as employee state insurance benefits in the event of injury of an earning partner, provident fund, compensation, medical benefits, etc., are examples of what the injured or deceased partner, by dint of her or his work, became entitled to, or the members of her family became entitled to. The denial of these and inability of the earning partner in a queer relationship, therefore, has an adverse discriminatory impact. The state may not intend the discrimination or exclusion in the conferment of such benefits or social welfare measure. Yet the framework of these policies expressed in favor of those matrimonial relationships results in denial of entitlements despite the professional abilities and contributions which the individual might make to society. The objective of many of these laws or schemes is to confer or provide entitlements based on individual earning and contribution. For example, Provident Fund is payable due to the employee's personal contribution and status as employee. Similarly, objective entitlement of benefits of employees' state insurance, etc., flow from individual status, work, and effort. Major part of these benefits, or all of them, flow in the event of certain eventualities such as fatal accident or death. The design of these statutes and schemes is to enable both the concerned subscriber or the employee to receive them, or in an unforeseen event such as death, for his dependents to receive them. The restrictive way in which dependent or nominee excludes their enjoyment to the intended beneficiary. Addressing all these aspects and concerns means considering a range of policy choices and involving multiplicity of legislative architecture governing the regulations guided by diverse interests and concerns, many of them possibly coalescing. On 3rd of May 2023, during the course of the hearing, the learned Solicitor General, upon instructions, had expressed the Union's position that a high-powered committee headed by the Union Cabinet would be formed to undertake a comprehensive examination to consider such impacts and make suitable recommendations in that regard. So we proceed to agree with the learned Chief Justice's conclusions with regard to the right of persons in hetero to marry under existing laws. On the issue of adoption, we express our disagreement and voice our concerns in the following manner. We have voiced our concerns and laid it out in some detail, which I do not wish to read. This is not to say that unmarried couples, whether queer or heterosexuals, are not capable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, the likelihood of their joining and cohabiting cannot be ruled out. In such event, de facto family unit can and does come about. The underlying assumption in the law as exists is that such heterosexual or queer couples should needs to be close. Similarly, the needs of such couples to have and raise a family in every sense of the term has to be accommodated within the framework of the law. The existing state of affairs which permits single individuals to adopt and later live as a couple in exercise of their choice, in effect deprives the children of such relationships various legal and social benefits which are otherwise available. Given the objective of to a married couple. In other words, given the objective of Section 57, the state as parents patriae needs to explore every possibility and not rule out any legislative choice to ensure the maximum welfare and benefits reach the largest number of children in need of safe and secure homes with a promise for their fullest development. Response to the this, comments on our draft, which I propose to read, part of which I propose to read. This court's observations with respect to the learned Chief Justice's reasoning centered around the enunciation of the bouquet of rights emanating from various provisions and locating an obligation has to be seen in the backdrop of the unanimous view of this court that the fundamental right to marry is not found within the Constitution. It is our considered opinion that to create an overarching obligation upon the state to facilitate through policies the fuller enjoyment of rights under Articles 19 and 25 is not rooted in any past decision or jurisprudence. That queer couples have the choice, cohabit and live without disturbance, testable. In the same, they are owed protection against any threat is the natural corollary of their right under Article 21. Consider in this context also the nature of relief sought and the positive obligation fashioned. Whilst there are innumerable judgments on the positive contents of the rights under Article 21, there are countless judgments that insist upon the separation of powers when it comes to matters of policy and the courts not being the appropriate forum for adjudication of the same. The polycentric nature of this issue is compelling. Next, as to the reasoning that our conclusion on the challenge of SM and subsequently finding on the disparate discriminatory impact faced by the queer community, a small comment is called for. The section discussing the provisions of the SMA and the challenge to its validity was based upon whether it violated the Constitution on the ground of impermissible classification under Article 14, for which the object of the Act to facilitate marriage between interfaith couples, wherein at the time marriage or even a couple only denoted heterosexual couples in the light of same-sex relationships being criminalized, and its provisions are relevant factors. Classification involves differentiation. Further, this court has discussed how underclassification per se does not warrant invalidation. In contrast, in the later segment on discriminatory impact, the issue that this court was considering was not reasonable classification, but impact upon queer couples through neutral laws or regulations that they encounter in their everyday lives, the purpose of which or even their substantive provisions have nothing to do with marriage. It is rather to confer other benefits, many of which are earned or accrued on account of individual skill. Yet the framing of these benefits or their intended beneficiaries were articulated in terms of entitlement to families or spouses, tends to exclude from its ambit queer couples. When such queer couples are entitled to benefits wherever they fulfill other eligibility criteria, it is the disparate impact of these neutral laws in the disbursement of entitlements or benefits which is seen through the effect or impact lens. Therefore, the discussion on constitutionality of SME is markedly different from the section on discriminatory impact in certain points for queer couples, as they have no avenue for marriage like heterosexual couples. In the latter, the impact of various laws were pointed as starting point for the state to take remedial action. Be sorely mistaken if we presume what the queer community in all its diversity seeks and lays it out as a formaic framework. Many may welcome civil unions as a pragmatic first step, while some may find it yet to be another inequitable solution to the feeling of exclusion that persists in society against this community, and one which simply repackages the stigmatization felt. Many may desire marriage as understood in the traditional sense to escape their societal realities, a form of financial and social emancipation from opposing natal families, diametrically opposite to assimilate and gain more social acceptance. Yet others may, as a result of their experience, reject altogether the institution of marriage and all the social obligations and associations that come with it, but still want protection of their rights. Certainly, what the former group may want does not hamper or hinder the latter in any manner, for it is a choice that they seek. That the state should facilitate this choice for those who wish to exercise it is an outcome that the community may agree upon. Yet the modalities of how it should play out, what it will entail, are facets that the state, here the legislature and the executive, needs to exercise its powers in furtherance of. Now, whether this will happen through a proactive action of the state or as a result of sustained public mobilization is a reality that will play out in India's democratic stage and something only time can tell. The state may choose from a number of policy outcomes. They may make all marriage and family related laws gender neutral or may create a separate SMA-like statute in gender neutral terms to give the queer community an avenue for marriage. They may pass an act creating civil unions or a domestic partnership, among the many other alternatives. Another consequence may be that rather than the union, the state legislature takes actions or enacts law. What is, however, certain is that in question of such polycentric nature, whether social or political, the court must exercise restraint and defer to the wisdom of the other branches of the state, which can undertake wide-scale public consultation, consensus building, and reflect the will of the people and be in their best interest. If as a result of this, a law is enacted that undermines or violates the constitutionally protected rights of an individual, no matter how minuscule, their right to seek redressal from this court is guaranteed. That the petitioners seek what many of us may deem to be normal or accepted next step in the life upon attaining a certain age, and perhaps take for granted is not lost on us. Their desire for social acceptability in the manner that has been historically known, through the social recognition that marriage affords, and the lack of which causes them the feeling of exclusion and hurt, is one that, as individuals, especially donning the robes of justice, we can certainly have deep empathy with. However, we are deeply conscious that no matter how much we empathize with the outcome sought, the means to arriving at such a destination must be also legally sound and keep intact the grand architecture of our constitutional scheme. If we throw caution to the wind, we stand at the risk of paving the way, wherein each brick may feel to untold consequences that we could not have contemplated. While molding relief as a code, we must be cognizant that despite being empowered to see the capabilities of the law in its grand and majestic formulation, we must not be led aground because we are blinded by its glow. Now I pass on to read the conclusions and the final directions that we have summarized. The court hereby summarizes its conclusions and directions as follows. There is no unqualified right to marriage except that recognized by statute, including the space left by custom. 2, an entitlement to legal recognition of the right to union, akin to marriage or civil union, or conferring legal status upon the parties to the relationship can be only through enacted law. A sequitur of this is that the court cannot enjoin or direct the creation of such result in legal status. The finding in 1 and 2 should not be read as to preclude queer persons from celebrating their commitment to each other or relationship in whichever way they wish within the social realm. 4. Previous judgments of this court have established that queer couples have a right to union or relationship, be it mental, emotional, or sexual, flowing from the right to privacy, right to choice, and autonomy. This does not, however, extend the right to claim a legal entitlement to any legal status for the said union or relationship. The challenge to SMA on the ground of underclassification is not made out. Equality and non-discrimination are basic foundational rights. The indirect discriminatory impacts on relations in relation to earned or compensatory benefits or social welfare entitlements to which marital status is a relevant eligibility criteria for queer couples who exercise choice to form relationships have to be suitably addressed and removed by the state. These measures need to be taken with expedition because inaction will result in injustice and unfairness with regard to enjoyment of these benefits available to all citizens who are entitled and covered by such laws. As held earlier, this court cannot, within the judicial framework, engage in this complex task. The state has to study the impact of these policies and entitlements. Consistent with the statement before this court during the course of the proceeding, the union shall set up a high-powered committee chaired by the cabinet secretary to undertake a comprehensive examination of all relevant factors, especially including those outlined above. In the conduct of such exercise, the concerned representatives of all stakeholders and the views of all states and union territories shall be taken into account. The discussion on discriminatory effects of the existing regimes on the queer couples. When a heterosexual couple's right to live together is not contested, the logic of the discriminatory impact faced by queer couples cohabiting together would definitionally, however, not apply to them. Transgender persons in heterosexual relationships have the freedom to and entitlement to marry. Regulation 5.3 of CARA regulations cannot be held void. At the same time, the court is of the opinion that CARA and the central government should appropriately consider the realities of de facto families where single individuals are permitted to adopt and thereafter start living in a non-matrimonial relationship. In an unforeseen eventuality, the adopted child in question could face exclusion from the benefits otherwise available to adopted children of married couples. This aspect needs further consideration for which the court is not the appropriate forum. Furthermore, the state shall ensure, consistent with the previous judgments of this court, that the choice exercised by the queer and LGBTQ couples to cohabit is not interfered with and they do not face any threat of violence or coercion. All necessary steps and measures in this regard shall be taken. The respondent shall take suitable steps also to ensure that queer couples and transgender couples are not subjected to any involuntary medical or surgical treatment. The above directions are in relation to transgender persons are to be read as part of and not in any manner whittling down the directions in NALSA, supra, so far as they apply to transgender persons. The directions are disposed of in the above terms.
View of Brother Ravi Bhatt as stated in the judgment.
I am conscious of the ordeals that arise from multiplicity of judicial opinions in cases involving constitutional questions. Yet I consider it worthwhile to pen the present opinion given the significant nature of the questions involved. Polyvocality in the exercise of adjudicatory function may not necessarily be viewed with discomfort if complemented with judicial discipline. It is truly reflective of diversity of judicial thought. At the very outset, I have given my conclusions while agreeing with the opinion of Justice Bhatt. I will read the conclusions. The question of marriage equality of same-sex LGBTQ couples did not arise for consideration in any of the previous decisions of this court, including the decision in Navtej Nalsa. Consequently, there cannot be a binding precedent on this court. The reasons for arriving at this conclusion are articulated in detail with Justice Bhatt. The rights of LGBTQ persons that have been hitherto recognized by this court are the rights to gender identity, sexual orientation, the right to choose a partner, cohabit and enjoy physical and mental intimacy. In the exercise of these rights, they have full freedom from physical threat and from coercive action, and the state is bound to afford them full protection of law in cases these rights are in peril. Third, there is no unqualified right to marriage guaranteed by the Constitution that qualifies it as fundamental right. I have given my detailed opinion. In one paragraph, I would read that. In my considered opinion, the institutional space of marriage is conditioned and occupied synchronously by legislative interventions, customary practices, and religious beliefs. The extant legislative accommodation of customary and religious practices is not gratuitous and to some extent conditioned by the right to religion and right to culture, constitutionally sanctified in Article 25 and 29 of the Constitution. This synchronously occupied institutional space of marriage is a product of our social and constitutional realities, and therefore, in my opinion, comparative judicial perspectives offer little assistance. Given this nature of marriage as an institution, the right to choose a spouse and the right to a consenting couple to be recognized within the institution of marriage cannot but be said to be restrictive. Coming back to the conclusion, right to marriage is a statutory right, and to the extent it is demonstrable, a right flowing from a legally enforceable customary practice. In the exercise of such rights, statutory or customary, the state is bound to extend the protection of law to individuals so that they can exercise their choices without fear and coercion. This, in my opinion, is the real import in the decision in Safin Jahan and Shakti Vahani. The constitutional challenge to Special Marriage Act 1954 and Foreign Marriage Act must fail for the reason indicated in the opinion of Justice Bhatt. Similarly, Justice Bhatt also rightly finds the semantic impossibilities of gender-neutral constructions of the Special Marriage Act and Foreign Marriage Act. On both E and F of his opinion, Justice Bhatt has exhaustively as to the reasons that they need not now be supplemented. I find no right to civil union or an abiding cohabitational relationship conferring a legally enforceable status cannot be situated within Part 3 of the Constitution. On this count, I too agree with Justice Bhatt, but I have supplemented it, in my opinion, having considered that there exists no unqualified right to marry. In the ordinary course, no occasion would have arisen for any further deliberation. However, as the learned Chief Justice, in his opinion, has arrived at a conclusion that there exists a constitutional right to a union or an abiding cohabitational relationship, it is necessary for me to express my opinion on this newfound construction. The learned Chief Justice locates components of the right to union or an abiding cohabitational relationship under Articles 19(1)(a), C, E, 21 and 25 of the Constitution. In my opinion, it would not be constitutionally permissible to identify a right to a union or an abiding cohabitational relationship mirroring the institution of marriage. The learned Chief Justice identifies tangibles and intangible benefits, that is, bouquet of entitlements that arise from state recognition and regulation of marriages. The Chief Justice further opines that the right to marriage is not fundamental. However, it is in these tangible and intangible benefits, the denial of which, according to the learned Chief Justice, must inform the reading of a constitutional right to an abiding cohabitational union. In other words, the benefits of marriage, however fundamental to a fulfilling life, do not make marriage itself a fundamental right, but they render the right to an abiding cohabitational union fundamental. I find it difficult to reconcile principles. I finally conclude, I will read the other last two. I also agree with the reasoning and the conclusions of Justice Bhatt with respect to constitutionality of regulations 5(3) of CARA regulations. I've concluded with, I strongly feel I am not to the concerns of LGBT with respect to denial of access to certain benefits and privileges that are otherwise available only to married couple. The general statutory scheme for the following benefits, gratuitous or earned, property or compensation, leave or compassionate appointment, proceed on a certain definitional understanding of partner dependent, caregiver, and family. In that definition and understanding, it is no doubt true that certain classes of individuals, same-sex partners, live-in relationship, and including siblings, are left out. The impact of some of these definitions is iniquitous and sometimes discriminatory. The policy considerations and legislative frameworks underlining these definitional contexts are too diverse and to be evaluated within a proceedings. Belief that a review of the impact of the legislative framework on the flow of such benefits requires a deliberative and consultative exercise, which exercise the legislature and executive are constitutionally suited and tasked to undertake. Thank you very much for this.
Thank you.
All right. So to our audience who have been watching here on YouTube with us, thank you so much. I'm going to give you some breakdown in context, okay? So this is where we are at this point. We have now the judgment of these 5 judges. Now remember, it's a 5-judge constitutional bench. So for anything to pass, you need to have 3 out of 5, at least 3 out of 5, to agree to change the constitution. So just to give you a breakdown of where we are, there were 5 judges, of which the Chief Justice of India, D.Y. Chandrachud, and Justice Kaul agreed that non-het couples should be given the right to marriage. But Justice Bhatt, Justice Hima Kohli, and Justice Narasimha have disagreed. They have dissented, which means that the 3 of them have agreed that there will be no right to marry for non-het couples. So what are we left with? Without that, we are left with all of the things that the Chief Justice has given us in the very beginning. Now, he had framed all of this, obviously knowing the difference in opinion. So they have repeatedly used the word union. Now, union, a civil union overseas, is what we call a court marriage. And what we call a court marriage in India is the Special Marriage Act. But this judgment very specifically says that it will not change the Special Marriage Act, which means that they're not giving us a civil union, or they're not giving us a court marriage for non-het couples. What this effectively means is the ability to coexist and have a recognized live-in relationship, from what I have understood. In this recognized live-in relationship, there are instructions given to government that these couples should be allowed to adopt, these couples should be allowed to have bank accounts, they should be allowed to have pensions, they should be allowed to buy, have homes together, they should be allowed to maybe take home loans together. The police should not harass them. The adoption is the main big headline over here, that all of these. So basically what has happened is, in this judgment, when the petitioners were making their arguments, they were saying that you should allow us to get married because we deserve equality, because there's a lot of discrimination against us. We're not able to open bank accounts. We're not able to take medical decisions for each other. We're not able to adopt. This is all important to being able to live. So what the court has said is that, yes, we agree it's important to be able to live. Yes, we agree that discrimination is bad. We cannot give you marriage, but we will make sure the government writes rules to the fact that these other things don't happen to you. So this is where we are at this point. There's no right to marry. There is a right to enter a relationship and have a union which will not be harassed, not be discriminated, which will have banking rights, which will have medical rights, which will have adoption rights. That is effectively what we have. Yes, Vaishali, live-in partnership was already possible, but you couldn't open a bank account together, or you couldn't buy a house together, you couldn't have insurance together, you couldn't adopt together. All of that has been changed. So that is where the big, change has come now. No, so Utkarsh, I think that Utkarsh is saying, does the three-judge dissent mean we don't get civil unions? See, I don't think we have such a thing as civil unions as they have in the States. We have our Special Marriage Act, what we have colloquially been calling in India a court marriage. That has not been changed for the benefit of non-het couples. So what you have is the ability to live in and enter a relationship with that is recognized, that will not be harassed by police, by banking, and by government. Adoption, all right. So adoption, there's a big change in adoption. The adoption laws, as pointed out by the Chief Justice of India, allows for single people to adopt. So a single person who's unmarried can adopt a child, but it did not allow same-sex couples or queer people to adopt. So the judge said that's completely silly because then one person out of that queer couple will adopt as a single person. So how could you not give them that rights as a couple? So that has been changed. Queer couples can now adopt together, jointly, as opposed to up till now, they would only one person would adopt. So that discrimination has changed as well. There are, of course, there will be, so basically there has to be a committee set up, headed, I think, by the cabinet secretary, who's among the highest IAS officers in the government. They will find rules in which all of these things can be implemented about the banking and all of that other stuff. See, guys, it is not, so we've not got the right to marry, but we've gotten a lot of other stuff. So it is not it's not a defeat. We've gotten a lot of other, the victories here, and we should take those victories, as has been given to us by the Chief Justice and the court. They have tried to basically take away a lot of the pain that was argued before them by the lawyers and the members of the community. So just to do, a recap of this, and let me just ask my team if there are any, guests that we can bring in at this point. But if you have any questions, let me try and answer those questions and try and break that down even further. So, Sam Enjoy says, in case a couple adopts together, later go separate ways, who gets custody? So that will basically, that will go to family court, like it would have if there was a married couple that adopted and went separate ways. Did not hear anything about banking and insurance rights. Has that been changed? Yes, in fact, Pallavi Agarwal, very specifically, I wrote this down. The Chief Justice said that bank accounts, that there will be a committee created headed by the Cabinet Secretary, and they will figure out how ration cards, bank accounts, nominees, medical decisions, last rights, inheritances, pensions, all of these things these rights should be given to couples who are in these unions. Let me see if there are any more questions that we can tackle at this point on this particular matter. So that's where we are. Okay, so my understanding of this, and we'll try and bring in the bigger lawyers and try and figure out the details going on a little further. We're going to try and talk to Geeta Luthra as well. But my understanding on this is simply this, that the court in a judgment that was 3-5 denies the right to marry to non-heterosexual couples, to queer couples, but has given them the right to a union, which will have, over a period of time, rights to ration cards, bank accounts, pensions, gratuity, last rights, inheritances, family rights. This committee will have to be set up. Also, the right against discrimination, which is a really big thing, and of course, the right to adopt. we're going to leave it there. If there aren't any more questions, I'm just going to see. Um, I'm going to see if we can get any more people right now to speak to us. Basically, what has happened is 3 out of 5 judges have agreed that there is no unqualified right to marry. So basically, unqualified right would be like a fundamental right where you don't need a qualification, in order to be able to get that right. And here, Justice Narasimhan, Justice Bhatt, and Justice Kohli have agreed that marriage is not that kind of right. It's not a right that you can demand to be given to everyone. We're going to try and get Tanushree Balla, a lawyer, joining us. Oh, Ashok Rakavi is with us.
I've come back. I don't know, something wrong with the connection, but you just
I'm so sorry.
keep on going on
No,
and off.
I just want your reaction getting into
Yeah,
it. There was a lot of mention of a union.
right.
Do you think that would be a civil union, or is that just an understanding of a live-in relationship?
No, it's a civil union. It's actually a step in the door to get at the entitlements. You are allowed to adopt. You're allowed to have the joint bank accounts. The police cannot come and harass you if you're living together. You have a right to be a partner of your partner has a right to be part of the family through a civil union. You know, uh, that giving them access to joint family and its resources. So I think it's a foot in the door. There'll be many interpretations of this as we go along, but
Hmm.
basically, I think we have got uh, our first step forward. No, of course, the marriage would have been impossible. Marriage, I had no expectations of marriage. Uh, uh,
Right.
I had no expectation of marriage. I knew very well that the Special Marriages Act would go into a dump because it is actually structured around heterosexual marriage.
Yes.
It sort
Oh,
of
oh,
cleans it of gender and all that. I mean, it cleans
Ashok,
it of
big
a caste.
wins.
Huh?
Big wins. Article 15.1, which is the right against discrimination, will now say
Right,
sexual orientation and
right.
adoption.
Yes, I tell you, the adoption is a big thing. So many lesbians have got children, and they've adopted children from other heterosexual families, and really they had no status at all. Even in schools and all, PTA used to ask them, "Where's the father?" You know, for the first time, that recognition has come. It is, I told you, a step in the door. I'm not happy that we haven't got the civil union actually like a contract. You know,
Yes.
it's good.
No,
It is
I just want
exceptional.
to read this out. I want to read this out to you. This is Justice Ravindra Bhatt's directions. Now, Justice Ravindra Bhatt was the dissenting note. He has
Right,
two other judges with him, so this becomes the majority decision.
right,
He
right.
says there is no unqualified right to marriage.
Correct.
Entitlement to civil union can only be enacted through laws. Courts
Right.
cannot enjoin such a creation of regulatory framework. A
Yes.
queer person is not prohibited in celebrating their love for each other, but no right to claim recognition of such a union by queer persons. He says queer persons have the right to choose their own partner. They must be protected to enjoy these rights. The union shall be set up, by a high-powered committee. Sorry, the union government will set up a high-powered committee to undertake the study of all relevant factors. So he's been very clear
That
about the fact that the civil union per se is not something that the court can bring in unless the legislature, the government brings it in, the parliament brings
uh,
it in.
you see, the point is they have kicked the ball into the cabinet, into the executive part of the government, in
Yes,
okaying the civil union. But they've sort of they're building the architecture for recognition that the police cannot this, they should be allowed to the. It's actually a very clever judicial way of saying we are on your side, but we're not giving you what you really want. I,
are you
I
seeing this as a victory?
I'm seeing as a foot in the door, not a victory. It's
Okay, a foot in the door.
a lot of LGBT think it's a victory, but there's a long way to go. From the fact that Faye, even things like we are not allowed to give blood donations, for example. Nobody has fought that.
Yes,
You have not been able to even change was something in the medical books where we are still called perverts and deviants, and then suddenly you want marriage. So I think every step of the way is going to be a battle. For example, civil union. Kya hai wo? Everybody will ask, what is a civil union? Can I go in front of a judge and or make a contract? like what we had, that Maitri Karar in Gujarat before it was thrown away.
Yes, yes,
So is it going to go that way? Where we'll have to fight every step of the way. But the important thing is they've taken away the repressive power of the state. They've asked the police to stay off, not to exploit
yes,
this. They've
yes,
said recognize their right. They've even said that we can be part of the family. If it's a big
yes.
family, access to family resources are social resources. So
Do you think,
I'm not
will there is,
happy. I'm not happy, but it's a ray of sunshine through a dark.
no, no. So I'm trying to understand here. Does this mean starting tomorrow morning, a queer couple can go to some office and register the fact that they're in a relationship? Or
Yes, 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 yes. In fact, this would lead to quite a few steps where, say, the aggressive couples, when I say aggressive, means those who want to fight for their rights, come out and go to the court and say, here is a contract. Accept this contract as a civil union. Accept this contract as a contract between two consenting adults in this country. And from there, the moment, if one judge accepts it, remember the high courts and all will start falling in line. One high court does it, it practically spreads like wildfire to the others, because the judicial system is connected, and is a unitary. It's not like just concurrent. So what will happen is that there will be now steps to actively ask for what is a civil union. Is it like the
yes,
French one, which gives us citizenship entitlement, which they've already given?
yes,
Are
yes,
you
yes. They've given
observing?
everything else. Yeah, see, they've
Yes,
given everything else except that certificate that says that you're married.
exactly. They
Yeah,
they
yeah.
expect.
So,
Come on, let us do some hard work too, instead of just expecting it on of a platter. I say, chalo,
but
abhi
you
jara
know,
get
no,
off
no.
your
So
asses and
I know you're a fighter, but
yeah.
I want to believe that in this country, we have equal rights without having one community to do extra hard work. Het people can just get married because they
No,
want to.
I
There's no
totally
hard
agree.
work.
I totally agree with you, Faye. But from the beginning of this whole fight, legal fight, how many groups have really stood up here? There is not even an iota of unity in the community, which was there for Section 377. You know, there was a mobilization across the subcontinent. We were all together, and suddenly everything defragmented. We have to learn to understand when to be
Yeah.
together. I knew that the one group goes and says, get us legalized under the marriage, Hindu special, I mean Hindu Marriage Act. Another one says, try to look at the tweaking of the Special Marriages Act. Framework to nahi diya. The judicial activism nahi kiya. Abhi, they've given us, okay, all the lollipops, but each lollipop has got a plastic cover. You can't put it in your mouth. I'm sorry, but
Okay, so I want to I want to just go through some of the questions that we're getting from our audience.
yeah,
Our audience is asking us to some clarification on trans recognition. Very important. I'm just going to cherry pick some of the stuff that I remember the CGI reading. He said they cannot be compulsory hormone therapy. A
right,
trans person will be recognized for the
right,
gender they identify as
right,
without forcing
right,
them to
right.
undergo hormone therapy
Medical
in order
exam.
to gain that recognition. Doctors cannot conduct surgeries on younger children without that child's consent. This is super important. Super,
Those
super
are
important.
very big victories.
Yes. And
Very big
trans
victories.
people in het relationships
Yes, yeah.
can
Are
can marry
recognized.
under the
Yeah.
laws that currently exist. Explain that to us, please.
Yeah, yeah. No, but it's already there. The Madras High Court has recognized a marriage between a Hijra and a male, for
Yeah.
inheritance purposes. So, we were there. We have to see that we mobilize across the borders, all the sectors, so that, at least in civil union are recognized. I think, for example, he says that the bench has said that we have a right as to be nearer partners when they're sick. If you read that, if you read the judgment, and
Yes.
have no idea how important that is. They keep us away from even the funerals sometimes, of someone we love. So it's like saying we've given you the 5 lollipops, 10 lollipops, but each of them has got a plastic covering, and you need to learn how to get that off. It means
Which
it's
is
a
this this
everything is a fine is a battle. Every step is a battle, and
So,
I think
Ashok,
with
there is, yes, there's a question about adoption, and we're going to try and get a lawyer to come and clarify this for us. But we know that this Chief Justice of India very clearly said that Kara's laws that do not allow queer couples to adopt are actually unfair, and
yes,
Kara is overstepping its grounds over here. But
right.
the dissenting judges, the three dissenting judges have agreed on this one adoption point. So where does that leave the
Mm.
final judgment? We're going to try and bring a lawyer in, if
Yes,
to sort of
if you
answer
need.
that for
It,
us.
it's not a
Um,
it's not a majority decision, right?
yes, yes.
Allowing adoption. Is it
I so I we don't know that. We're going to have to actually look at the the final judgment that comes out. It's normally out by the end of the day, and actually read through that document to
mm,
understand.
mm,
My understanding from most of mainstream media has put out saying adoption is now allowed for queer couples, but there seems to be some question. So I don't want to jump the gun. I want to let's try and get that checked on adoption as well.
mm. I think so. I think so. On the whole, I'm not happy. I'll be very
You're
frank.
not. Okay.
But
Okay.
I have a foot in the door. Now it's going to be a fight every battle. The war's on, and we are winning these small battles. If you say that a heterosexual world got everything on its own, well, it's a heterosexual world. We are still a minority, and as a minority, we have not learned to be unified. The transgender is fighting its own battle. It was a bundle of battles put together. Transgender in Nalsa got didn't get what it wanted. We haven't got what we wanted here. So, it's going to be, are we going to be together again? Or are we going to fight this out as single people, you know, as single couples? It's not happy. I'm not, at the age of 77, uh, I am seeing this, that we are not together. And I'm very, very sorry to say that I'm not happy with that. If anybody's
So
expected that, I've got a call from Alaska, and he's taken his boyfriend there to get married. That's fine, but our battle is here now. It's no use going to America to get married. So what? You said something, Faye.
yes, so my understanding, and this is what I'm reading out of live law, that says that the final outcome is the Supreme Court has refused to recognize same-sex marriage, and says the
Right.
legislature, so the Parliament will have to do so. It
Mm.
has recorded a statement of the Union government that it will constitute a committee to give those rights and benefits
Right.
to queer couples. Supreme
Yeah.
Court holds that transgender persons in heterosexual relationships have the right to marry.
Right.
Deepa Chandrachud Justice called said queer couples have the right to adopt, but Justices Bhatt, Kohli, and Narasimhan have agreed and upheld that queer couples do not have the right to
Yeah.
adopt. Zinab,
So
Patel is here. One second. Zinab, your reaction. I'm
right.
So
sorry.
basically, my
What's your
reaction
reaction
is
to?
So my reaction is very simple, just 5 points. So they talk about the recognition to cohabit. We all knew that was there, but it's a new articulation from the judiciary that sets a precedent. Recognition to and the right to enjoy queer relationships without discrimination. But this is opening the door for any kind of further legal action on, say, a progressive anti-discrimination bill or whatever. Trans people have the right to marry in and recognize in, but then again the challenge is, as articulated in heterosexual unions, so someone has to identify as a man or as a woman. So Faye, for a person like me who identify as a woman, it's probably easier if I get another person who identify as a man in the relationship. But it's a strange kind of win for us in the community, and yet we have to stand in solidarity, the state to form a committee, like for example. But let's also look at the fact that an expert committee under a cabinet secretary was formed even before the Nalsa judgment, and that
Mhm.
committee recommendations never saw the light. It was never even presented in court. when the Nalsa judgment was happening. So
Correct.
I don't even know the efficacy of that, but I think there will be some band-aid approach in terms of a state appointed committee under the cabinet secretary to look at certain rights, like as I said, the rights of marriage, inheritance, etc., so on and so forth. That could be a band-aid approach that the state may consider, and ensuring that people are not subjected to any kind of medical procedures against their own will. So I'm at least glad that they have talked about conversion and all of
Trans,
these.
yeah.
That is something positive,
And
but it's,
surgical procedures.
and I think, Faye, through your medium, we need to correct people's perception. What people have done is given self-congratulatory messages once they have read statements made by Justice Chandrachud over his reading of the judgment. And while they are all very progressive, and it's like it's actually
Sounds great.
interesting, sounds amazing, but the fact is one has to look at it and not get into a self-congratulatory mode, but also correct some of the misconceptions that people
Mm.
may have, that people now have the right to marry. Please go ahead, have the right to marry, right to adopt. Unfortunately, we've stopped short of that. But as
Yes.
I said, before in the call, what were my expectations setting? At least there is something recognizing the state to look into some institution. I was not overtly positive, like for example, everyone there's
Now,
going to be a
so
marriage
let
law.
me let
Then,
me
yeah.
then let me just put this in a nutshell
Thank you,
again
sir.
for our
Mm.
viewers from what we have understood, right? Um, so Supreme Court has not recognized the right to marry for queer couples. That's one.
I think-
Two, the Supreme Court has not, unfortunately, recognized the right to adopt for queer
Right,
couples.
right.
The Supreme Court has asked the union government, and the union government has agreed to set up a committee to look into the various rights in banking, medical records, inheritance, pensions for queer couples. Transgender people in heterosexual relationships can marry, but they always could. This is not new, and this is not out of this one particular judgment. So, and all of the directions given by the Chief Justice to the government on non harassment is a sort of reiteration of the rights of these individuals anyway. Is that correct?
Yes.
Yes, but these are just directions. I think the fact is that, see, even when, and I'll just correct you on one point, that although trans people have been cohabiting with their partners for a very long time, whom we call husbands, wives, or whatever, it's just that legal recognition was not good. The fact that the Supreme Court said now that trans people in heterosexual relationships can have legally permissible marriages under SMA or under the personal laws, I think that opens the door for
Those are
trans
top.
people across the spectrum. So I definitely see that as a departure from a non-existent kind of untalked version to something that is now based in law.
Is it based in law?
They have made a judgment. I'm
I
going
mean,
to say that. See, Ashok, my lawyer called me up and she asked me, is there something I should tell the price? I said, "Yeah, please tell people I am now single and available to marry. I just need someone someone
oh,
with a bungalow in GK1 or GK2 to approach me.
but
That's the only
I've been ready to marry for the last 40 years. I mean,
But Ashok, you don't have a bungalow in GK2.
no, I want in a 20 floor tower next to the Zizamata Udyan. Anyway, the point is, they've given us hope. They switched on the light, but nothing. Then the bulb is not coming on.
See, Faye,
Because I
also
don't.
the framework for the engagement and the
Yes, but
timeline has not been set. Just
that's
like
not
in
that
the
a framework is not a direction and doesn't become law. That's the
No,
sad.
so Ashok,
Yeah.
I'm just saying that one perhaps then looking at the supposedly shortcomings of the Navdev Johar, where the government was actually directed to start anti-discrimination campaigns,
Right. Right.
etc., so on,
Right.
to destigmatize LGBT relationship, which never got into any
That's
practice.
yes.
I think one needs to just look at the court to look at least the contempt of court if there is no such practice happening within a reasonable amount of time, and to make sure that whenever a committee which is powered by the cabinet secretary is set up, to be able to fruitfully participate for those who are intending to do this. I think I would take that as the next steps.
What I kept on telling Faye is that they've sort of shown us the lollipop. each lollipop is covered with a plastic this. We can't really get to the lollipop. We have to fight now for every bit of the way. It's like a bouquet where we don't even have the right to take out each flower and see it on its own. So I am getting more and more disappointed because this business of uh, you know what do you say, adopt. I thought Faye had was telling me about a majority judgment, but it obviously looks as if we don't have that right either. There's no majority judgment there. So
No, I'm
it's a
sorry. That, yeah.
yeah. So we are up shit creek. Sorry for the bad language, but the point is that they've shown it to us. ये देखो तुम्हारे सामने, like uh, we do with the cats, and nothing beyond that. I mean, kicking the football up to the secretary, cabinet secretary, is exactly what you went through in the Nalsa judgment. So the
Yeah.
ghanta mila wahan, you didn't get anything.
In
That
in
note has not been seen.
uh, Ashok, I'm just going
Huh.
to play this. We've just got a response here from Geeta Luthra, a senior
Okay.
advocate at Supreme Court, who's put out her understanding and her response after this judgment. I'm going to try and play it out for our audience right now. My producer Shubhankar is standing by. If you can put that up for us, please, Shubhankar.
It is with bated breath that everyone has waited for the same sex marriage judgment. And I am so happy to see that in the judgment of the Chief Justice has in fact said the same bundle of rights which every married couple has should be available to the same sex couples. Now, this is extremely welcome. At the same time, three judges and Justice Bhatt gave the lead judgment, who incidentally has had one of the most brilliant and most exceptional careers as a judge, who is retiring on the 20th, 21st, has said in his lead judgment that marriage is a statutory right and therefore it cannot be given by the court under Article 32. Justice Paul has elaborated on the formation of the committee as suggested by the respondent state and by the learned Solicitor General, and has said that it should be a committee which should have a very representative character. The major concern and the stepping stone should be that even if the right to marry has not been given, which it has not, at least the bundle of rights which have been referred to by Chief Justice Chandrachud, that is, rights with regard to naming a person, right with regard to insurance, right with regard to adoption of same-sex couples, all those rights. So we have to move further from Navdeep Johar. Navdeep Johar had opened the issue and was long awaited. Now, I had felt that in consonance with the South African two judgments and with other judgments the, of Europe, I had felt that perhaps, and most importantly, the US judgment, I had thought that further steps would be taken and that there was a possibility that same sex marriage would be recognized. But
The
All right.
what the
So that
heterosexual
was
marriage.
Geeta Luthra who sent us a response on, on that judgment. She was in court and among, the lawyers who argued for it as well. So now, so in your mind, what is the next step going forward? I think, I have to accept, I initially thought that adoption was something that was given to us. It sounded very strongly that it was given to us. It was only after we realized that there were three dissenting on the other side that adoption was not given either. That's a big blow.
So yes, so the part of the dissenting judgments that were read out by the other honorable justices kind of did not agree with the statements made by the Chief Justice. But I think I think one is that let's hook on to the celebratory approach. There is still something to celebrate in the judgment. Never before in the history of the rights movement such proactive statements being made. We When this case was being put up in the Supreme Court, we all did know that there are going to be several loopholes, several roadblocks. If you ask me my personal view, Faye, I'm happy that if there was a overwhelming judgment in favor of, say, same-sex marriages or marriage equality for all, I perceive there would have been a roadblock in the parliament to roll back that. So I'm still happy that there is something that is being looked forward to. As a petitioner, I would look at a time frame for implementation of certain directives, not losing time and holding the court and the government responsible for framing that committee to look at possible ways ahead, to look at some rights of civil unions and marriages that can be granted to LGBTIQ couples in general. So I would basically look at that, and also be sure to file a contempt petition within a period of time if there is inaction on part of any other stakeholder, executive or legislative, in terms of failing to do their duty to this, because it's a very hard small win and we don't want to lose.
Right, so obviously the battle will continue. Is there the question that everybody's still asking
Wrong.
is there a possibility of a civil union that
Inter-
can be registered like they do it overseas? Is that your understanding from this so far?
Because again, the committee is looking at the specific rights within marriage, inheritance, as you talked about, joint bank account, property, critical care, etc. It's not specifically telling the committee to look at civil unions per se. So that is, I did not read it, but I may have missed it, but I'm not a legal expert. But if there is a legal expert who has a more in-depth view about what this committee could look at, I I very much doubt that there is a civil union on cards.
no, it's not mentioned. They haven't said that civil unions
Yes,
are.
Ashok, that's what I actually said. That unless I have
Yeah.
missed that part, and some
No,
legal
no.
luminary has a different point of
No,
view
I
on this.
did not hear anything about civil unions. That the registration of civil unions. That's what I said. It may have to be challenged. You may have to go to court, sign like that Maitri Karar thing in Gujarat, and see whether we have been living together for 10 years. Show them the receipts or whatever, your joint account which you are supposed to have, and then say now we want a civil union. But imagine what a fight it's going to be. It's going. It's good. It's a tough fight. You know.
The point is, Ashok, we don't have it right now. As in,
That's what I'm saying. You don't
we
have
don't
it.
have it.
You
We don't
see,
have it.
the
Yeah.
point is you may have to prove that you've been together for so many years, and therefore we want the civil union, the right, or something that is there on paper. Nothing is there on paper. Am I right,
Nothing's there on
Zainab?
paper. Yeah. Yeah.
So I've said
I
I'm
mean,
very disappointed.
effectively, yeah. So, I mean, as we unpack it,
Unpack.
there's not much
It's
really to take home.
I got very upset when you talked about adoption, Faye, and unbundled that nonsense.
Yeah.
I'm not
Unfortunately,
on.
yes,
Say,
Yeah,
if you
um,
personally ask me, I see this as an abdication by the Supreme Court to rule on the
yeah,
rights of
yeah.
minority by saying this, put everything
They
in
put
the
their hands
domain.
up.
Yes,
That
in
they,
that way, saying that okay, we should be doing this,
but we
but
can't. That's
and
right.
I just see this as abdication, because the fact is that whether it's the current day government or any consecutive
Any
or
government.
past government, they have just remained non-committal on this thing.
yeah.
It's
I
not just
I must
non-committal.
tell you,
It's
yes,
total priority, non-prioritization, and kicking us into a corner. The football, like what happened to you all, that note from the chief secretary never came to the committee. Am I right, Zainab?
No,
When
no,
they
no.
asked,
They came. They did come, Ashok. It was a male gentleman. He was very good, but the question is that there is a certain level of responsibility that
Yeah.
the executive would have in terms of the legislative.
Mhm.
So I think all of those good recommendations are just wise words in an old book unless it's implemented by the legislature.
Right, right,
So
right.
yes,
That's I
Yeah.
like that abdication is correct. I've said they put the hands up. They've given us every reason to hope, and then put their hands up and said that
Yeah.
only the
Actually,
executive can do
so
this.
unfortunately, and I'm going to be honest, the Chief Justice's judgment was so positive when he was reading it
Yes,
out,
I went
his
on that.
opinions, his stands,
Yes,
that I think we all started to feel a little buoyant about the fact that, something might come out of this. But as we unpack it, we realize that there isn't much. Even the committee, even all of the rights that we thought we were going to get will go to a committee that the government will look into, and only after that passes through government will we have any of it. So effectively, if we look at it again, the right to, for example, ration cards, bank accounts, pensions, gratuity, all of that, it's only after the committee gives its report that the government, according to the Supreme Court, will be bound to implement that report. And we've seen in the past also, say, for example, police reforms. Supreme Court gave a judgment, but nobody actually implemented those police reforms at all. So we've seen sort of governments, when they choose to drag their feet, they can really drag their feet on certain things. The right to adopt has not come. We understand that the union is not a civil union. It's perhaps just a relationship, that will not be harassed from,
yes.
if we
It's a
were to
very
put it in
negative.
those words.
It's a very negative definition, of how
Yeah,
we should
yeah,
get recognition. I mean, it's
you know,
after you get beaten up, then you go to court and say we're together. Please don't beat us up. But you already got it. It's
yeah.
disappointing. You're right, Faye. The
the
CJ.
abdication of the Supreme Court can be summed up in actually what was said by Justice Bhatt, that all queer people have the right to choose their partners, but the state cannot be obligated to recognize the bouquet of rights flowing from such a union. So for me, when you're
Is
saying
he
these
said that?
things,
But yeah, he
Justice
said
Bhatt,
that in print,
Yeah.
right? Oh God,
it's part
that
it's
is
it's part of the transcripts, Ashok. But it's
yeah, yeah,
interesting, so one has to measure both and see the way forward. So for me, when somebody says that, it's a clear cut abdication, that it's not my responsibility, it's somebody
yeah.
else's responsibility to look at this
It's saying
bouquet of rights.
yes, I see you, but I'm walking past. It's
You're
That's
what?
what it is. You're walking
Yeah,
past.
yeah,
I'm walking past. I see you, but I'm walking past. How
Yes.
many of us do to people we don't like? That that's what it is. Fair. I'm so sorry. I'm thankful that I'm on this show where we could clear our minds as the
yeah. I'm
judgments
so
were being
sorry.
read out.
This
Yeah,
is
not.
this is
Why should you be
quite
sorry?
heartbreaking,
Yeah, it
unfortunately.
is heartbreaking. That's
Yeah,
another word I think I would use. It's abdication, it's heartbreaking, and it's letting us, uh, you know, l- foot loose in the middle of nowhere. That's what it is.
yeah. I think that effectively now, there's a lot of. If I were to look for the silver lining, if the two of you would permit me to look for a silver lining here, there's a small one. It's very tiny, which is basically a lot of the observations being made by the Chief Justice at the beginning in his note could perhaps be used, in arguments in smaller courts to take things forward, which would be to argue for rights, to argue for, we argue against discrimination. But yeah, the
Faye, I
big
want
things
to
that we
tell
came
you,
for.
I want to
Yes.
tell you that I have been in conversation with some of the lower judicial officers and all, and they just call him a woke, sober guy, the CJ. You know, he's just a woke sober guy. जो भी बोलता है वो हो नहीं सकता है. That. So don't go by that. Be very clear. that what they say and what they do are two different things. And
So I think that, in this
yeah,
case, the Chief Justice is the dissenting judgment, which is a rare
yeah,
thing to see.
exactly.
Yeah, we don't normally see the CJI's judgment as the dissenting judgment, but that's what it is here. Um, so unfortunately to my audience,
Oh,
now this is becoming clear to us. We don't, non-het couples do not have the right to marry. Non-het couples do not have the right to adopt. You do not have a civil
nothing.
union. You what you have is some instructions to government against discrimination. But that first point, Ashok and Zainab, where the Chief Justice said that Article 15 will be, we will have sexual orientation written into Article 15.1 against discrimination. Does that stand? Do we have that?
What's the use of that without the rights flowing out of it?
See, I
Zainab?
mean to say all of those sounded nice, but I didn't
Yeah,
see any concurrence on that, in terms of the proclamations by other judgments.
Mhm.
That
if Bhatt
I
says
just want
that
to say
they don't
I
have a
did
right,
not read it in any of these.
yeah, and well, uh, it looks like from I reached the top of the mountain and came sliding down and hit the base
Yeah, yeah,
without a safety net. Sorry, uh, I don't know. It's
yeah.
clarified my thing now. Let us see. We'll have to take the bad news because some people are jumping around thinking they've got marriage and civil rights. And actually, a lesbian couple phoned me said, "Oh, lovely! I heard we've got this right to adopt." I'll have to tell her she's got no such right. Well,
Yeah.
thank you, Faye.
Un-
Thank you for having
Thank
us
you.
on.
But
Thank you.
look at it
Thank you, Ashok.
from
Thank you, Zainab.
just a silver lining, Ashok. Imagine me in an immaculate white dress with a tiara standing outside the church in Vadala, waiting to get married.
Which church are you talking
In
about? Say,
Vadala.
Paul?
I am not going to name any churches, Ashok.
Oh, oh.
My parish is St. Paul's Parish, but I'm
I
not going
oh
anywhere
God, yes,
close.
I know.
Zainab, with due respect to your tiara and your white dress, even if in an alternate universe the Supreme Court allowed it, the Catholic
The
Church
church,
is a different, that
different
is a
cup of tea.
different kettle of
You
fish to
and you can't.
battle
You
completely.
cannot
Yeah.
say that I'll wear something that looks like the Pope's gown either. You know that. Anyway, uh,
Bye bye, Ashok.
I don't know whether
Bye.
you guys are seeing the tamasha that's going on. That the church has taken a contrary stand and is anti-Israeli stand. Huge tamasha going on. And
Yeah,
the
yeah. All
I
right.
okay,
Yes.
That will have to
yeah,
be a separate conversation.
yeah,
I'm going to
yeah.
end this conversation here. I want to thank both of you for sort of
That is
holding our hands through it. It's been a slightly rough morning, I'd say, for members of the community. So I'm glad that we were able to be here and sort of break that down. We're going to try and understand it a little further through the day as more and more, as the actual documents come
and
out, the judgments,
yeah,
and we're able to
and
read them
thank
out
you,
better
Faye,
as well.
for actually pinpointing those small things that burst the bubble, and brought
Thanks,
us back
Ashok.
to reality. Thank
Thanks,
you very
thanks, Sarah.
much.
Thank you. Thanks,
Bye,
everyone, for tuning in.
Zain.
We bring you, bye, bye, Sarah. We bring you more updates and more understanding of this as we break this down even further. Thank you all for watching.